Good evening, everyone. Today is Monday, February 10th, 2025. The time now is 6:05, and I will call to order this regular meeting of the Town of Mead Board of Trustees. In accordance with the town's remote participation and remote meeting policy adopted by the Board of Trustees on March 13th, 2023, by Resolution Number 21-R-2023, remote participation will be allowed. The meeting link has been provided on the town's website, designated posting place 24 hours prior to this meeting. I'd like to remind everyone present, both in person and virtually, of the town's general guidelines for public comment at open meetings and public hearings. The guidelines are available online and on the entry table. There are 2 public comment opportunities on the agenda for persons in attendance at Town Hall to address the board. The first is limited to items on the agenda, and the second public comment opportunity allows any subject, whether it is on the agenda or not, to be addressed. Mary, roll call, please.
Mayor Whitlow.
Here.
Mayor Pro Tem Harris.
Here.
Trustee Adams.
Here.
Trustee Babcock.
Here.
Trustee Crane.
Here.
Trustee Hagan.
Here.
Trustee Schranz.
Here.
Mayor Whitlow, today is Monday, February 10th, 2025, and you do have a quorum.
Thank you, Mary. Please join me in a moment of silence for all of the victims on the January 29th plane crash in Washington, D.C. Let's reflect on their lives and the loved ones they left behind. Thank you very much for your time. Please join me in the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much for your time. Next is review and approve agenda. Are there any changes to the agenda this evening?
I'd like to take letter E out of the consent agenda, resolution number 12R2025 out.
Okay, thank you.
Just for some general clarification and discussion.
Okay, thank you very much. Trustee Schranz, is there a motion to approve, or excuse me, may I have a motion to approve the amended agenda?
I'll make a motion to approve the amended agenda.
Thank you. Is there a second?
Second.
Thank you. Roll call, please, Mary.
Trustee Schranz.
Yes.
Trustee Adams.
Yes.
Trustee Hagan.
Yes.
Trustee Babcock.
Yes.
Trustee Crane.
Yes.
Mayor Pro Tem Harris.
Yes.
Mayor Whitlow.
Yes. Thank you. Motion carries. We have an approved agenda for this evening. Next is our staff report by our town manager. Ma'am, you have the floor.
Thank you, Mayor. Trustees, you have my report. I do have a couple of things I'd like to point out. First of all, Sweet Flower opened this weekend. We were able to get the CO issued last Friday, so we're excited to see another business opening downtown. Also, I did want to make you aware, the first Wednesday evening of every month is the I-25 Corridor Coalition. And of course, we're front and center because our segment is under duress or construction, depending on your opinion. And then, of course, we have the 1601 process where we're looking at a potential interchange at County Road 38. We did learn at the last meeting that the chairman, Scott James, wants to look at potentially bringing these meetings back in person. So the next meeting we are going to have is going to be in person at the annex building. So if anybody's interested, you can jump on now if you want to, but it'll be an interesting meeting to bring in the people. That's how the meetings were until COVID. So I don't know if there's a move afloat towards that, but we're looking at it for that group. I also wanted to let you know that Manny, our pavement management manager, will be presenting at the next board meeting the 5-year plan for pavement management. So looking forward to hearing that. And then finally, I know I give you updates every week on what's going on the intersection and all the various projects. And we had anticipated that the 2 houses would be torn down. last week, but that we're still waiting for the testing results of the mobile home, the asbestos testing. You can't get a demo permit until you've done the testing and prove there's no asbestos. And if there is, then you have to remediate. So we're waiting for that. And then once we get that, I think they're going to take them down at the same time, right, Erica? But it's moving. Anybody who's been by there, they're doing a lot of digging, and you can really start to see the shape of the intersection taking place. So, and that's all my additions to my report.
Questions or comments for Helen? Okay, seeing none, thank you very much for your time. We'll move on to our informational items for this evening. The first one is our Mead Municipal Court update. And we have in the room our Judge David Thrower. Sir, you have the podium. Thank you for joining us tonight. And we're not in trouble. Yet.
Mayor, members of the board, it's a pleasure to be here. It's a bit bizarre to be on this side of the podium. I haven't practiced law as an attorney in a few years, so I suppose it's good to be back. I just have some comments for you about the basics of municipal court. I was talking to Mary in the hallway. This is a version of the Citizens Information Academy that I offer in a different jurisdiction. Usually lasts about an hour and a half, 10 minutes max. I'll get through it. Okay. And then when we get done, if you have any questions, just let me know and we can have a chat about municipal court and how it works in Mead. The court is a forum for alleged violations of the municipal code. As I'm sure you all know, there's differing levels of courts, federal, state, and municipal courts. The municipal code is what we enforce in our court, and that is obviously enacted by you all. There are a number of different kinds of cases that come before the municipal court. Some of them are criminal, meaning that they carry with them the possibility of jail. In this jurisdiction, that possibility is up to 364 days. Some jurisdictions, no jurisdictions can exceed that amount by state law. So that is the maximum that can be found. There's also a $1,000 fine as a potential maximum. There are other cases which are not subject to jail, such as traffic cases. We'll talk about some numbers at the end of my chat, and you'll get a flavor of what kind of cases come through the municipal court here in Mead. There are some offenses, traffic offenses that carry with them the possibility of jail. Those are typically things that are set as jailable offenses by state law, such as failure to have insurance, reckless driving, things like that. We see a fair number of those actually in this court. The municipal court is staffed by myself as presiding judge. Kristen Brown is our associate judge. She fills in for me when, for whatever reason, I can't be here. I have a tremendous amount of respect for Kristen. I'm thankful for the opportunity to continue to work with her. The prosecuting attorneys are those that represent the town, and the town is represented by the Osmus law firm. They take care of prosecutions. That's what they do. They have 27 courts, I think, something like that. I work with them in 5 of my jurisdictions. I'm the presiding judge in 7 jurisdictions, back up in 3, so a total of 10. I drive a lot. I want to be sure and recognize Marisol Herman, who's here with us tonight. She is our court clerk. It's absolutely true that she's the face of the court. I'm here once or twice a month. She's dealing with folks that have to come to court on a daily basis, and it's not hyperbole to say I couldn't do it without her. She's doing an amazing job for the court, and I'm privileged to work with her. Mary is also sort of the administrative head of the court in the sense that she provides services for the court. She's been so supportive to me in the 7 years that I've been here, and she has my gratitude. Quick review of the process. I'm going fast. The process for municipal court starts with a ticket being issued by law enforcement, whatever agency that is. Typically, it's the police department. It can also be code enforcement. The next part of the process is an arraignment, and that's what you see mostly taking our time in the municipal court. People come before the court to be read the charges against them, their rights. They also have an opportunity at that time to meet with the prosecuting attorney. Thanks to the amazing remodel of this room, that process is a lot better than it once was. So we have some privacy for folks to be back with the prosecutor, and I'm not hearing the conversation, which I'm not supposed to hear. So thank you for doing that. It also affords us the opportunity to have better and more robust security. My thanks also to the Mead Police Department who are here when we have court, making sure we're all safe. That is a big deal. It didn't, when I first started being a judge about 10 years ago, it wasn't as big of a deal as it is today. I won't do court in any of my jurisdictions, big or small, without security anymore, ever. So thanks to them. Thanks to all of you for the reconfiguring of this space. As I said, at arraignment, I'll explain what the charge is, make sure they understand it. If they want to talk to the prosecutor, they can. That generally results in, if we've all seen Law and Order, the plea bargain. And that is an opportunity for generally a charge to be reduced or changed in exchange for a guilty plea. That takes care of about 98% of cases. And that's not unique to this court. That's just true. Courts don't have the bandwidth to try every single case. It's just not possible. So generally speaking, the prosecutor will make a plea offer, and if it's accepted by the defendant, I have the final say as to whether I approve it. We are blessed with prosecutors who I think come up with fair and equitable offers. My goal that I'll come to when we talk to sentencing is to try and correct behavior. Punishment is part of what I do, but correcting behavior is probably the biggest part of what I do, particularly at this level. Most people that come before the court have made a mistake, and it's usually often their first mistake. We do have others that have perhaps more experience in court than maybe even I do, but generally speaking, the people that are here are concerned that they're heard and concerned that they understand what's happening, and I feel that's the most important part of my job, those two aspects. If the plea is accepted, a guilty plea will enter to the amended charge, and I'll sentence them at that time. Doesn't have to go that way, and it sometimes doesn't, and when it doesn't, the matter will be set for trial. Most of the time, trial will be to the court. However, there is a right to a jury trial, depending on whether or not jail is a possible penalty and some other factors that are kind of technical. We haven't had to have a jury trial in here since I've been here, in the 7 years I've been here. But certainly we're prepared to do that if we need to. It does happen. If there is a trial, and if let's just assume for the sake of this presentation it's to the court, generally municipal court trials are an hour or two. If it's a traffic case, 30 minutes, depends. Prosecution calls witnesses. They have the burden to prove the charge beyond a reasonable doubt. The defendant doesn't have to even put on a case or say a word. If the prosecution fails to prove the case beyond a reasonable doubt, a silent defendant will be found not guilty and they will be acquitted. Part of my job is to make sure they understand all their rights. Buddy Soul can tell you that they have a lengthy written advisement of rights that they need to go through. And I will also try to take whatever time I need to make sure they understand all of that. If they don't understand it, I can't accept their plea. That includes defendants that perhaps need some assistance with interpretation. So we have interpreting services that are available to us, both live and via electronic means. In one of my courts, our interpreter is an iPad that sort of walks around the courtroom and helps us out with that. I do speak a little bit of Spanish, just enough to say we need a new court date and to get an interpreter. My wife speaks fluent Spanish. We try to have Spanish only weekends. My record is 3 hours. If someone's acquitted at trial, they're done. If they are convicted of the charge, sentencing. As I said, if jail is a possible penalty, that's a possibility. It is very rare at this level that somebody will be sent to jail. Depending on their background, jail can be part of the sentence and it can be suspended pending completion of probation. What I look for as a judge is evidence-based sentencing that I think will deter somebody from doing this same thing again. That's, to me, the fundamental portion of my job at this point in terms of sentencing. Punishment certainly is part of the process, but again, the first and foremost goal for me as judge, if somebody's convicted, is to help them find ways to not do this again. Sometimes that includes coming back and seeing me a lot. We can set matters for review and I'll check in and make sure people are abiding by the terms of their sentence. Sometimes the prosecution will offer a deferred sentence agreement, which is their form of probation. All of these things are designed to get some buy-in with the defendant to comply with the ordinances of the town of Mead. One of the things I don't like to have to say, but I have said it in a neighboring jurisdiction to an individual who I think I saw for 6 months in a row, is that I was working harder on their sentence than they were. When that happens, we have to sort of find some alternative means to encourage people to comply. That's court. That's the process. What does the court not do? It does not provide legal advice to the town. My learned colleague over here, Marcus, does that. We do not have jurisdiction over civil matters. So if you want to sue your neighbor about some kind of a boundary dispute, this is not the court to do it in. We do have jurisdiction to impose restitution, however, and that is considered a civil matter. We do not have jurisdiction over alleged violations of Colorado statutes. So if it's a Colorado statute and it does not appear in a companion ordinance in town of Mead, this court does not have jurisdiction to hear those cases. That's what our court does not do. In terms of the specifics for the town of Mead, we have one evening arraignment session on the third Thursday of every month, 5 o'clock. Come see what it's like. I would encourage all of you to come by, have a seat, and see what happens at municipal court. I've been told time and again from elected officials that they were surprised about what they see in municipal court. We used to start at 6:30. I was graciously allowed to change to 5 p.m. and that's been going really, really well. Gets people out of here a little earlier and keeps me fresher longer as the evening goes on. Our average attendance at court is 30 to 40 per session. One of the amazing things that our staff does here is they call defendants and remind them to be here. Lots of people wonder why that's necessary. So do I. I wonder a lot of things. I wonder why I wasn't taller, for example. But in this day and age, constant contact with people that have obligations to the court is the way you get compliance. It's just fact. If people don't show up for court, what do we wind up doing? We wind up having to tie up the police department and resources with warrants in certain cases, or we have to enter a default judgment with the Department of Motor Vehicles. Because Marisol calls defendants, our FTA rate in Mead is by far, by an exponential factor, the lowest of any of the 7 courts where I preside. I would say if we have a docket of 40, we'll see 37 people. In other jurisdictions, I'd be lucky to see 20. So good on her. Right now, it's breaking 50% traffic, 50% criminal. When I spoke to this group last time, which was kind of a long time ago, we were doing more traffic than criminal. So we're kind of at a 50-50 split. The caseload for the court has been very consistent through the years that I've been here. For example, in 2024, we had 688 cases come through court. In the previous 2 years before that, the average is about 550. Even during COVID, our numbers in this court were consistent with the needs of public safety, in my opinion. Last comment, we do see some animal cases in the town of Mead Municipal Court, and I'll just leave you with this thought. Those are generally the hardest cases we see in these courts. Certainly the hardest for me. I was at dog training earlier with my dog today, so, but they do happen. And we take them seriously. One of my jobs is to make sure that animals don't constitute a continuing threat to the public. I do take that seriously. Usually we can find a way forward that includes some training, but it is something we do here. I promise you that was my last point. I told you a story. One last point. We do hear juvenile cases in this court. Those tend to be juvenile cases that are traffic based, but they can be other things like possession of marijuana, possession of alcohol prior to lawful age. This court does not have jurisdiction to place those juveniles into jail. We do have the jurisdiction to place them in the juvenile hall for up to 48 hours in certain circumstances, though they are very rare. That's Municipal Court 101. Questions, comments?
Thank you, Judge Thrower. Thank you very much for being here tonight. I really do appreciate it. I will open it up for comments or questions. Trustee Strands, okay, and then Mayor Pro Tem Harris. Go ahead.
Just a quick question. You mentioned your court case is running 50-50 between traffic and criminal. What is a typical criminal case?
Assault, theft, those are criminal cases. Anything that's a jailable offense,
Okay,
disturbing the peace. Things that you would normally think of as low-level misdemeanor offenses.
okay, thank you.
Being the mother of 6 children, 4 of which are drivers, I've had the pleasure of attending municipal court a few times. This may be a question more for Mary, but I'm curious, if you did have to do a jury trial, how would you get the jurors? Would Weld County send out jury note? How would you get the jurors? That's just more of a curiosity thing on my part.
You can use utility or tax records. That's generally the way most jurisdictions do it. In one of my jurisdictions, they did it by going out on the street and saying, "Do you live here?" and pulling them into the,
Really?
that was a little before my time, but
Huh. Okay.
that's kind of old school.
So it's not, we would be in charge of our town only getting the jurors
100%.
for our case.
Absolutely right.
Okay.
And I can get voter records from Weld County.
To
Probably, since we're not all on utility, we'd probably use them.
Mhm.
And then we'd randomly pick from the Mead voter records.
Huh.
Right.
You seat a jury of 6, just to finish the thought, we would probably need to have 50 people here.
Mhm.
Wow. All right.
Trustee Bagpo.
As also a mother just to 2, but teenage drivers, I have had the pleasure of sitting in here and I agree. I was shocked. I have been previously on the Board of Trustees and heard about court, but until you come in here and see how many people she gets through and you get through, and really how busy it is, it really, it's eye-opening. But you run a really awesome court. It's actually very you can see that you want to educate them and not have them back. So it's, dare I say, entertaining to see, but thank you for what you do, because I don't think anyone realized with little old Mead, what happens here, but we have lots of cars and so traffic things are happening. So thank you.
Much appreciated. Thank you.
Anything else? Okay. Anything, Helen, Marcus? Okay. Judge Thrower, thank you very much for not only being here tonight, but being our judge and all the time that you spend with our children and our adults, getting them back online. So thank you, sir, very much for being here tonight with us.
My
with us.
absolute pleasure, Mayor. Thank you.
Thank you, sir. All right, thank you very much again. We'll move on to our second informational item tonight, which will be our police department overview, by our police chief, Newbanks. Sir, how are you?
Very good. Thank you, Mayor, trustees. Pleasure to be here this evening and give you an overview of the police department. I think you've heard from pretty much every other department in the town. So this will probably be the last one of those. This is going to work. Oh. So this is an organizational chart. I know that's a little bit difficult to see if you're far away, but essentially 19 total employees within the police department. Commander and I comprise the administration piece of that. And in the patrol division, you can see there's 2 sergeants, 10 officers. Underneath that same structure reside the 2 school resource officers, which you see in purple, and the code enforcement CSO in green. And there's one of those blocks is empty, but we do have that candidate in the final phases of being hired, and we expect them to start early March, which would put us at 16 sworn, which is fully staffed in position we've not ever been in. So we're looking forward to that. And then underneath, also underneath Commander, are 2 civilian staff. One is records evidence. That's Michelle, and new to our staff is Melissa, who's the administrative clerk. And I'll go through a little more detail about all those positions as we move through. Hiring and training, that's kind of where it all starts. When we added a commander to our organization, that was essentially the direction he was given. Hire and staff our department and provide the training that they need to meet, not only meet the standards that's required, but exceed that. And that's exactly what he's done. So that process starts with an application. And I can tell you over the last several years, the number of applicants has been quite slim. And we are not getting, we used to get hundreds of applicants for a position. We're not getting tens of applicants for a position. We're getting a handful of applicants for a position if we're lucky. That has seemed to improve somewhat over the last 6 months, but it still seems to be like a fairly small pool of candidates, and they're being competed for very heavily amongst departments. So once the applications come through, they're reviewed. Those that meet the basic requirements are given an interview. That interview panel is typically comprised of commander, one of our civilian staff, and usually a sergeant. They ask a standard set of questions to screen those candidates and vet them. And if they're passed on, there's a chief's interview after that. And at that point in time, if they successfully complete that part of the process, they are offered a conditional job offer, which includes psychological testing and background investigation, medical testing, and successfully completing that does get them hired. So I wanted to just show the little graphic off to the right. There are the numbers last year that we ran through backgrounds, just to show that not everybody makes it. It is a very scrutinized process, and we're looking for the best. So it does what it's supposed to do. And we close to 50-50 on that. So just so you have an idea. Patrol and investigation, sort of the heart of the department. The 10 patrol officers respond to calls for service. We are dispatched out of Weld County Regional Communications Center, as are all agencies in Weld County. Our officers typically, when first hired, go do a ride along in dispatch and just to see what's going on up there, which we found improves that relationship a little bit. Also offers the officers a perspective about what's going on the other side of the radio, and why sometimes they may call dispatch and have silence for a little bit, because they're busy with a lot of things that you don't know are going on unless you've been up there and seen that. Similar to court, if you haven't been there, you don't quite get it. Same thing in dispatch. So that's one of the things that we try to do with all new officers. The graphic there shows the different types of responses. Emergent calls, typically, a lot of those are traffic crashes. We do respond to some medical calls, but usually that's only in a situation where we think we could beat the ambulance there and provide some medical attention that would actually be effective. If it's a less serious medical call, typically the ambulance goes on that and the officer does not, unless the paramedics call back and request law enforcement for some reason. And so, sorry, that graphic is really quite small. The bottom, the biggest number there is investigations. And so what we mean by that is really follow-up. If you look at our calls for service, over 9,000 in the year, there's a whole bunch of those that are labeled follow-up. And so officers take their own cases and they work those cases. So as their day goes along, if they're not busy with a call that they've been dispatched on. They're following up on their prior cases and trying to work those through to a conclusion, either a filing of charges, or the case might, if there's not enough leads to solve that case, it may get suspended. But they're working through those to try to come to a resolution. And so that's part of what that investigations piece there is. We do have one of our officers is a part-time officer, Rob Palmer. He is very interested in investigations and has sort of taken on that role in the sense of becoming very attuned to the paperwork that's required, writing warrants, writing subpoenas, and the completing the required paperwork. So there are cases where an officer working night shift has difficulty completing investigations simply due to the access to people during times when they would be awake. Most people don't really like their door to be knocked on at 1 a.m. to answer a few questions. And so sometimes they do need someone else to help them in that case. And so a lot of times Officer Palmer ends up with those types of cases to follow up on and complete. We do not have any permanently assigned detectives at this time. It's all reliant on officers to complete their own investigations or get another officer to assist them in that. And then, of course, supervisors are monitoring those cases to make sure they're completed. Can you move that to the next one, Marisol? Thank you. Records and evidence. This is Michelle. She's records and evidence. Primarily in records, she's looking over police reports. We are on Weld County's system of records management system, which is also the same program used for CAD, computer aided dispatch. So as the call is input by the dispatcher and sent to the officer, it comes up on their computer in their car. They're responding to it. And then once they cut a report, it goes under that same call. And the information is captured in that records management system. So Michelle's role in that is a lot of quality control to make sure all the information was captured that we need for that report. There's, depending on what the case is, there might require NIBRS reporting. It might require a filing with the DA. And so Michelle is making sure that that report includes all of the things necessary in there to get through that process and be complete. So a lot of times supervisors do review reports before they're sent to Michelle. And she's that sort of final review and making sure it's all good before it's signed off on and shared either with the DA or outside of the department. And so she also handles requests for any type of information to be released that's could be in the form of a core request, which Mary deals with on the clerk side. Most of our requests are considered CCJRA, which is Criminal Justice Release Act. And so it's slightly different than CORA in some cases. To be honest, we rely on our legal advice quite a bit on what can be released to what can't be released because it's extremely complicated and changes frequently. So Michelle receives a lot of training on that, but it's a lot to keep up with. We also have state mandates for some other reporting, school statistics, officer contacts, and demographics, and those are also handled either through a records management system or another contact reporting software that we use for officers to collect the demographics information that the state requires that we report for any contact. And then evidence. This is records obviously takes a majority of Michelle's time. So we have tried to really make evidence as efficient as we can. And by So we have a standalone software system that captures evidence information. Officers can use their cell phone or computer to enter that information and log in the evidence. It then prints out a barcoded label. All evidence has that barcoded label on it. And so when Michelle gets it, evidence is packaged, barcode label on it. She can take that, place it in our evidence storage, which is the converted shop. If you remember that presentation a short while ago, that was fitted for evidence storage, and she places it in a box. And then in that program, when we need that piece of evidence, either for court or disposal or whatever it is, she knows exactly where it's located and can go find it, scan it out, and take care of it in that way. We also do auditing in evidence. That's part of our accreditation standard through the Colorado Chiefs of Police, and also part of our policy. And the most important part of evidence really is disposal. We can't continue to build shops or add shipping containers. We need to move evidence out of there as quickly as possible. So our system is very good at documenting, how long that evidence needs to be stored for, and then identifying it when it can be released. A lot of times that requires a release from the DA's office, and if it's been part of a criminal filing, which is another thing that Michelle has to keep up on, is asking for those, requesting those releases. And so lots of documentation and keeping up on that. Like I said, that's a whole separate system just to log evidence and keep on track of what can be disposed of. Next, we'll go to school resource officers. We have 2 full-time school resource officers, one at the high school, and then one that splits his time between middle school and elementary. And their primary role there is really mentorship and presence. We want them to have a positive relationship with the kids. We want to start building that in elementary and middle school so that kids don't have a fear of police. They see police as someone who can help them, and that's really important for us to begin that process there. So the number of criminal cases coming out of elementary and middle school is obviously very low. That's the way we would like to keep it. And we would hope that we'd have that positive influence there to keep that going. And then we work with the schools on discipline. Obviously, the schools take care of the day-to-day discipline in all of the areas that they can. They do have a threshold. Once it kind of reaches that threshold, then in some cases they're asking the officer to step in and consider maybe a criminal enforcement for whatever it is, once they've sort of reached that threshold of where the school is comfortable in maintaining that enforcement piece. There's kind of a gap between those two. And so not too long ago, Sergeant Salazar was in here giving, I think it was then Officer Salazar, but now Sergeant Salazar, you a presentation on juvenile justice, which is a diversion program. And so that began at Mead High School and is now a model for the rest of the school district. And so they're working to actually put that in place throughout the school district. And it sort of fills that, the idea is to fill that gap. So once the school has done what they can do, there's another piece. There's a lot of criteria that has to be met there in order to be eligible for that. But it does give another alternative before they end up in court. And obviously our goal would be worst case scenario to send juveniles to court. It is necessary. There are some ways to get there sooner than later, fighting being one of those, simply no tolerance for that in the schools. And so a lot of times in those cases, it jumps straight to enforcement. But most of the other things can be progressive. And so that's what we've tried to maximize, is that ability to do as much as possible and offer students education and ways to alter the behavior prior to utilizing court. Our administrative clerk is a position in the front desk that we just filled. Melissa Merkel is our new administrative clerk. And this person really takes on a lot of responsibilities. They wear, we all say that we wear a lot of hats around here. She wears a lot, mainly because there's so many areas in the police department that we really need a backup for. And so all the things that I talked about that Michelle does, Melissa tries to be the backup. In case Michelle's out for an extended period of time, she would be able to step in and maintain those tasks and perform those duties in that limited capacity, at least to keep us going in her absence. And so that's a lot of training that Melissa will go through to come up to speed on that. She has a background in law enforcement previously, which is very advantageous for us because she has a lot of good understanding of processes and what happens in a police department. So we're lucky to have her. But besides taking walk-ins at the front desk and answering the phone, she does sex offender registrations. We have about 8, I think, on the list right now that are registered here in Mead. Some of those are quarterly registrations, some are yearly. And she's responsible for maintaining those files and notifying them when they're due for registration, and then moving that investigation to an officer should someone fail to register. Records assistance, entering data, quality control, all of that. She's responsible for knowing the pieces that would be required in an absence of the records evidence person. Also assisting with the release of reports, video, and other evidence, mostly video redaction. That piece, as you know, with all of our body cam video, we're soon to be adding dash cams, more video, all of which has to be redacted if it's released publicly. And so we have outsourced that redaction in the past, and we're looking and vetting and hoping to move to more of an AI-based redaction software in the near future, which will reduce costs, also speed up the process and allow us to do that in-house instead of farming that out. So there's also the piece of we're not quite sure still where the state's going to land on our ability to recoup costs for that. And so this would ensure us that we could wouldn't have incur large sums of costs due to farming out that redaction piece. Administrative support, clerical duties. Commander and I obviously task her with a few of those once in a while. She also will do research and construction of statistical reports, logistics, inventory, ordering and distributing of equipment and supplies as necessary. Obviously, the equipment we have in our cars that needs to be replenished, those stocks and things, someone has to monitor that. And so that's a part of what she does. Fleet maintenance is also a part of what she does. We use a program called Fleetio that monitors our vehicle inventory. And so she will get notifications when an oil change is needed, when tires need to be swapped out, or that type of various types of service. She will schedule those and then a lot of times assist in getting the vehicle to whatever shop it is for that maintenance and back. And financial invoicing is also a piece of what she does. We already talked about redaction of video. So as you can see, like plethora of things that she does. And so important that we found someone who likes to do a variety of things because it's a lot. Commander and I oversee the department. So these duties are split out between the two of us. The policy, we have 638 pages of policy related to the police department. So this requires constant updating and reviewing. As laws change, we subscribe to Lexipol, so they tend to send us updates to our policy. Sometimes they work just fine and we can plug those in and go on our way. Other times, in particular due to Colorado and some of our laws, more specific to law enforcement, we're required to kind of go through those and rewrite those to be acceptable for what we do. And as you can imagine, trying to write policy, blanket policy for police departments is very difficult because a small department like ours operates much differently than a Denver PD or larger agency. So we do task Marcus's staff frequently with reviewing those policies and making sure that what we have fits what we do and could be supported. Accreditation through CACP, that's typically been a 5-year accreditation because of the requirement from the feds for that to be renewed every 3 years. We think that's going to get bumped up. So we will probably be redoing that here pretty soon. And that ties very closely with policy. Obviously, a lot of those requirements are to have policies about various things. Recruitment, hiring, training, retention. This are things that Commander Smith, like I said, has been very involved with since he's been here. And kudos to him for getting us to a fully staffed state. He has done a ton of work over the last 3-4 months in particular to get us there as quickly as we have, even with the loss of 3 officers late last year. Budgeting, planning, leading. This is something I think we tend to share between the two of us. It's our honor to do that. And we certainly have a great staff that makes that very easy. The next slide is on training and collateral assignments. So we have our own in-house instructors for a lot of the training that we do. That would include firearms, defensive tactics, and driving, which are considered the kind of the big 3. And law enforcement post requires us to have 12 hours in those areas, combined in those areas is a minimum every year. And so we do have instructors in all 3 of those areas. We also have a TASER instructor. That picture is someone wearing a VR headset. We subscribe to that training and have implemented that. And so that helps with training on the TASER. TASER cartridges are really expensive. So officers are required, I think, to shoot a couple sets of those every year as part of the recertification. But as you can imagine, just like shooting a firearm, if you shot your TASER twice every year, doesn't make you real proficient at utilizing that device. So the VR headset, you can do hundreds of reps at no extra cost, essentially. It allows you to have moving targets and all that kind of thing. So very helpful. And that TASER instructor is another instructor that we maintain. Collateral assignments we have for drone, crash investigations, and peer support. So those are just other areas that officers specialize in and maintain either certifications or certain amount of training to remain proficient in those areas. And then we also have SWAT. We're have a contractor, an association with Longmont SWAT team. Sergeant Ellis is a member of that team and maintains that connection. And they provide a significant amount of training for us. Probably most importantly is active shooter training once a year, which we do in one of the school district buildings We did it at Mead Middle School just not too long ago, but it moves around to various schools throughout the district. And that basically helps us to be ensured that if we had an incident here in Mead in our school district, the neighboring agencies that are also part of that school district have trained the same. And so responding to that incident would be, we'd be much better off because we train together and train alike and have the same concepts that are supported by Longmont's tactical unit. And finally, community events, obviously very important. And we put a lot of pride in being present at those. The public interactions that we have at these events are priceless. I really appreciate the support to be able to do that. And that is, I think, one of the key things that we take away from that. But in preparation for those events, we're always mindful of the event safety. I think certainly on everyone's mind after a number of the incidents that have happened at public events around the nation, around the world. You know, we think of those things and we're always trying to think of ways to make those events safer and certainly have things in place that we need to respond if something were to happen. And so that planning and so forth is taking place behind the scenes, and officers are not only there to just interact with the public, but also to be eyes and ears for anything that would be a danger to the public in those situations. And obviously participating in those, we hope we're building community trust. And by developing those relationships, having those opportunities to speak with people in the public. And that is something that we plan to continue. And finally, I included a slide with our last Citizens Police Academy. We plan to run the Police Academy once a year. We've been doing that in the fall. And that's just an opportunity for some advanced education for anyone in the public who would like to seek that. And it's been an excellent opportunity to connect with people in our community and really share with them what Mead Police Department is all about, and hopefully educate them on how they can help us, because that is truly a partnership, and we need that community support out there. Obviously, the community is out seeing a lot of things that we can't be everywhere. So we want them to know when they should call us and when they need to report something. And that's a big part of what the Academy is. We also share a lot about the training we do and the things that officers see and deal with every day out on the street. And I think it goes a long way just to help have that understanding throughout the public. So I know this was a little long. I tried to streamline it as much as possible. If you have any questions about any part of it, I'm happy to answer any questions.
Questions or comments for our chief?
Chief, I had one question. When you were talking about that only about 50% of the applicants make it through to be an officer here, what were some of the reasons why somebody would be denied, since they're all obviously officers to begin with, correct?
Not necessarily, but in most cases, yes. And I would say in most cases where they failed a background, it doesn't necessarily mean there was something really, bad, criminal or anything like that in their background. But there might have been something questionable about actions they took as an officer, or, and we don't get to see, we don't get to ask for, we don't get to see their any of their IAs or if they've had any of that in their previous employment until they reach that background stage. And so it's usually something coming out of that. It could be something as simple as we contacted a couple of the references and they don't give a good reference, and they maybe bring something out. I really think this person is not cut out to be an officer, and for some reason, something like that. And it also could be something just glaring in their IA jacket from their previous employment that was a bad use of force or a inappropriate contact, something that we think doesn't go with what we're about here in Mead, then any of those things, combination of those things, would justify that. Also, the person's background, financial background, some of those things are taken into account, and that's part of being a police officer. You are just held at a higher level, and so a lot of those things just don't get vetted until that background stage. And like I said, we try to be pretty picky about who we take. So that's where they're getting disqualified.
Okay, thank you.
Are you notified if an applicant has a Brady letter?
There, we would find it in our background. Usually, an applicant will not hide that. I mean, they know you're going to find it. So, I've received phone calls from officers wanting to apply here, and they just go, "Can we just have this conversation now? Because I don't want to go through the whole process and get weeded out at the end," kind of thing. And so sometimes it comes up that way, but we would find it in the background. We would check for that. We would check the Post database to make sure that they're in good standing with Post, and those types of things are all covered in the background. But we would not be notified necessarily. We would find that on our own.
Tricia. Well, I would just want to say my kids love Tom. He's the best SRO. All my kids love him. I was just curious, in the beginning, you said we're getting very few applications compared to previous years. What do you think is the reason for that? Are there fewer officers coming out of the academy, just fewer, like what do you think is the reasoning for that? Just out of curiosity.
There are a lot of people at the age ready to leave law enforcement, retiring. And I think when we saw a couple years ago, when we saw some of the issues come up with qualified immunity and sort of some of those negative things, it encouraged some people to leave, probably prematurely, maybe find a different line of work or go to a different state. And so thinned out the pool a little bit. And then we weren't, for a while, academies weren't full. And so there weren't enough coming out. Now, what we're seeing is that all of the candidates in the academy are already attached to an agency. So there are very few coming out that are not. Pueblo is one of them that was their academy last fall was about 50-50, and we picked up Officer Bagano from that academy. But Ames, Front Range, those academies are full of candidates who are already associated with an agency. So unless we do a process to hire a candidate and put them in the academy, we're not getting anybody out of those academies. So that's the other piece that has sort of gone away, and why you're seeing more lateral, like we're getting more laterals, because that's sort of all that's available to us.
So do those agencies then, are they paying for them to go to the police academy then? So they're kind of sponsoring them, or how?
I can't say 100% they are. Most of them that I know about are paying them to go to the academy. So they're hiring them, doing the whole hiring process prior to the academy, paying them to go to the academy, and then, a year later, end up
Have
with
to
an officer.
compete with that with a small budget.
Yeah, we actually have that candidate recruit. I think it's listed in our pay scale. So we're set up to do that. The issue for us is being so small. If we put one candidate in the academy and expect them to A, get through the academy successfully, and then B, get through FTO field training and make it succeed, chances are, not great. Maybe 50-50 that you would, maybe better than that, but we would hire, right? So it'd probably be better than that. But still, I mean, it would be devastating to lose that person 7 months in, and have that investment. So larger agencies that are putting 7, 8, 9 through at a time, they expect to lose a couple. And it's, you know, and it's okay, right? Because they have that volume. They're just kind of part of the expectation. We just don't have that volume to sort of make that work as well. But I fully expect sometime in the future we will do that. And currently the state is grant funding the academy. So no one's going through the academy and paying for the academy themselves. The state has been covering that cost through grants. So that's the other, you know, thing that's going on is agencies aren't paying for the academy. They're using this grant to pay for it. They're just paying the person their salary, whatever that is, while they're in there.
Okay. And do they then have a commitment to like work for that agency probably for a certain amount of time once they get out, which kind of limits them being able to move as well?
So we already do that with new officers, have that requirement of the initial piece. So either a year or two, they're on a contract.
Okay.
And if we put someone through the academy, yes, we would have that. I know there are agencies that don't. Why? I'm not really sure. I think they just don't want to mess with it. If the person wants to leave, they're like, let them leave kind of. There's some different philosophies on that, but you know, to be consistent, we're kind of already doing that to some level. So if we put someone through the academy, I would expect us to do that, but it's kind of hit and miss from what I've seen with other agencies.
Any other questions? Thank you, Chief. I would highly encourage anyone here in the community and the trustees to go see the dispatch center. I've seen it twice. It's amazing. And if you have an opportunity to go tour the jail, from the outside looking in, obviously, but Captain Turner gave us the tour last time, and he does a wonderful job of doing that with the jail. But the dispatch officers, or whatever they're called in their professional, they are amazing. I mean, Chief and I went last time, and it's just, I mean, the monitors that they have to wear, you know, it's just amazing. So I highly encourage anybody in the community to go and see. And if there's a chance that we can put on a tour to go see it, I would encourage you guys to go see it. They are amazing folks. Amazing. So thank you, Chief, very much for giving us the update. And thank you tell your officers, thank you on behalf of all of us.
Thank you very much. I
Okay.
appreciate it.
Thank you, Chief. All right. Our third informational item tonight is our SIRSA board member training. And I'd like to invite the Deputy Executive Director, Sam Light, who is General Counsel for SIRSA. Previously, Mr. Light was a partner with the Denver law firm of Light and Kelly PC, specializing in municipal and other public entity law, insurance law, and defense of public entities and elected officials. Sam is a frequent speaker on public entity risk issues and municipal law and has practiced in Colorado since 1993. And I've had several opportunities to sit in a room with Sam and others and get educated more and more every time I'm with you. So thank you, Sam, for being with us today.
Thank you, Mayor. Thank you, trustees and staff, for having me out this evening. It's great to see you all again. I know you've got a couple of new faces on the dais, but some that I recognize as well. So thank you again, Mayor, for that introduction. By way of just a little bit further introduction. So I'm the Deputy Executive Director and General Counsel for SIRSA, which is the acronym for the Colorado Intergovernmental Risk Sharing Agency, which is kind of a mouthful. That's why we call it SIRSA. So we're the town's insurance provider for property and casualty insurance coverage. So we provide that insurance, you know, for everything for the property coverage that covers this building, the auto physical damage coverage that covers your police vehicles and other vehicles, to the liability coverage that covers all these risk exposures, everything from, you know, maybe a slip and fall outside of town hall and there's a liability claim for that. We cover that all the way up to law enforcement liability coverage. And probably most interestingly, from your perspective, we provide your public officials liability coverage, which protects you. And we'll talk more about that in a little bit. Just a little bit more about SIRSA. We're not a commercial insurance company. We are owned and controlled by Colorado municipalities. We were organized under Colorado statute back in the 1980s as a public entity self-insurance pool. So our only book of business, our only insureds is insuring Colorado cities and towns and affiliated entities. We're owned and controlled by our members. Our board of directors is made up of municipal representatives around the state. I think that emphasizes an important part about pooling, which is this concept. We are all in this together, right? Just like you are managing and serving in a fiduciary capacity over the assets and funds of your own municipality, we collectively, right, as municipalities have gotten together to pool and manage our risk collectively. To give you a sense of our size, we currently have about 295 members in the pool. That's about 90% of the municipalities in the state of Colorado. One of the things we do at CIRSA, we take care of the bread and butter stuff, like getting your insurance policies in place and the renewals and so on. But we also, we deal with claims. We have a claims department that takes care of those things. But we provide resources for our members around risk, liability, and risk management. So the purpose of my visit is one of the resources we provide is we do elected and appointed official presentations on liability issues and managing risk for you all at the governing body level. So that's the purpose of my presentation this evening. We try to get out and visit our members and provide those presentations at least once every 2 years for our members. And I looked, and it's this week, exactly 2 years ago, that we last visited as a group. So I do want to make my presentation to you as helpful as possible. So feel free to ask questions as I go through the material, with one disclaimer that you heard last time. If you were here last time, I'm happy to take questions as we go throughout. Please just grab my attention and I'm happy to take questions. But if your question is a question about the live burning issue of the day that you've got going on in Mead, for which you need legal advice, that's for your Marcus and your town attorney team. Same thing if my radar is telling me that your question is really about something that's in your manager's wheelhouse, then on both those points, I might give you suggestions or thoughts a little bit from CIRSA's risk management perspective. But if you need legal support from your town attorney, that's for Marcus and his team, and manager, that's for Helen and her team to provide you with that support. There are a couple of handouts that I think Mary passed around that if you want to learn a little bit more about CIRSA, there's a CIRSA at a glance pamphlet that talks more about how we're different than other carriers and the resources that we provide our members. And then particularly for the new members, the ones who were here last time, you already may have gotten a copy of this, and you probably have it on your nightstand, and readily available as a risk management resource, right, as a public official. But that's our handbook for elected officials. And then there's a couple of other handouts that I'll go through and mention briefly as I go through the materials. So let's dive in, make sure I point the pointer to the right place, and we're good. All right. I'm going to talk about some topics that we visit every time we meet with our members. That's going to talk about the role of being an elected official. We'll talk about some hot topics around transparency risk, mostly open meetings issues. I'll talk about organizational structure and liability, and a little bit about quasi-judicial decision making at the governing body level. So those of you who were here last time, you saw this slide in a slightly different form, but I always put this slide up here because I think this slide shows us some things around risk management that mean certain things at certain points of time. And we kind of look at these thoughts through the lens of where we are here and now. But do you agree, particularly with the new trustees, and congratulations on your election? I know it's been a little bit of time since the April election, so you're getting comfortable in the role. But for both the newer folks and the people who've been on the board for a while, do you agree with this notion that once you become an elected official for the town, your role and relationship to the town and the community changes pretty dramatically, right? Right? You're no longer just a private citizen, right? You're a public official, an elected official, and I'm here to tell you from a certain perspective, that's a 24/7 job, right? Please have a personal life, please enjoy it. But in the eyes of your constituents, right? In the eyes of your citizens, in the eyes of you, people you take counsel with, they will always, in any setting, right, perceive you to be an elected official, a representative of the Board of Trustees as an institution, and a representative of the town as an entity. And it does have certain risk management consequences to it. Becoming an elected official, you're no longer an outsider to town government. You're now one of the insiders. And one of the risk management dynamics there is that on the inside, right? It may feel a little constraining sometimes, but on the inside, there are all sorts of state statutes, town ordinances, boards' rules of conduct that apply to us and stick to us. And the fiduciary obligation requires, right, that we're bound to follow the rules that apply to how we as board members individually and collectively make decisions and do our business. Recognize also that now that you're on the board, you're a representative and an ambassador of the organization. In a legal sense, you're a fiduciary, right? We all know what that concept means. But from an attorney's perspective, the fiduciary obligation can be described this way. Fiduciary obligation is the obligation to place the interest of the entity that we represent as a fiduciary, the town as a corporation, above all other interests. And the fiduciary responsibility requires us, to put that interest and the public interest above all other interests. Part of what that means then is if you can analogize yourselves in the public sector analogy to the board of directors of a corporation, and you are. We just call it the board of trustees. At that corporate board level, right, one of the primary fiduciary responsibilities is protection of the town's interest and assets at that high governing body level. And I guess it means, particularly with respect to policymaking, is that one of the key decision-making questions is, what's the right thing to do for the town as a town? And hopefully, a decision that you make as a board that will stand a test of time. Do you agree with this notion that sometimes that's not, it's going to be kind of difficult, right? Right? Yeah. But that fiduciary responsibility, among its other attributes, it requires, right, as part of our service on an elected, public, multi-member governing body, that we have the ability, both individually and collectively as trustees, right, to put the town's interest and the public interest above narrow, personal, single issue, or other interest. Also requires a commitment to consider issues on their merits alone, right? Despite all the other pressures that may be, or the tugging that may be appearing. Maybe you have a certain decision where only these rules apply, but you're being tugged in a certain direction. You have to be willing to push those aside, right? Let me drill down just a little bit more on this concept of fiduciary, because it's mentioned under state law. In the beginning of the Colorado State Code of Ethics, it says that the holding of public office is, quote, a public trust, right? Created by the confidence which the electorate reposes in the integrity of local government officials. So again, that fiduciary responsibility, right? If we keep that in mind, it's not always in the forefront of our mind, but if we default back to that, right, and ask ourselves in the face of a difficult decision, right, or the pressures of public office, what's the right thing to do collectively as a board that'll serve you well and help you manage risk appropriately? If you continue that analogy of, well, what are our duties as fiduciaries? There's not a lot in state statute about what it really means. What are the individual pieces of being a fiduciary? But if you think about fiduciaries applied in other contexts, it means things like a duty of care, taking care, right, to protect the assets and fiscal assets and property of the town as a corporate governing body, a duty of impartiality, particularly when you're making decisions where impartiality is absolutely required by law. We'll talk more about that later in the presentation. A duty of accountability, right? That's what the open meetings law and the open records law are set up to expect of you as public officials, and a duty to preserve public trust, right, in government. So you agree with that notion that sometimes it's not going to be that easy to figure out what that public interest is? What's the best thing to do for the town? You ever have that situation where, let's say you've got about 6,500 residents, maybe more, but growing every day, right? Yeah. Even when this room is packed, right? If you've got an emotional, high-profile issue and this meeting room is packed and, you can tell emotions are running high and people are passionate and you're thinking up there at the dais, well, whatever decision we make, it's probably not going to make everybody happy, right? But recognize in that moment that the obligation, right, is not to necessarily follow the interest of the small but vocal minority, but to keep in mind that you represent the interest of the entire municipality, right? It includes thinking of perhaps the silent, right, but larger majority that expects you to act in the public interest. One good risk management tool in those situations when things are kind of tough, right, is to remember that one of your prerogatives as a board, working together collectively, is to take the time that you need and get the information that you need, right? That will help you make good decisions. So even in that situation where, maybe you've got a packed house and people want you to make a decision tonight, if you feel like you need more time to deliberate as a board, or you feel like there's more information you might need, maybe it's from your town attorney about what authority you have and what options you have that are defensible, or maybe it's from Helen and her team about where does this fit in our work plan? What resources do we have to address this issue? Then it's your prerogative to take that time. Knock on wood, it's not a lot of our claims that we get at CIRSA, but some of the liability claims that we get involving decisions made by an elected body or an appointed body, in hindsight, it's pretty self-evident that the decision was taken in haste, or it was a overreaction to something going on in the moment, or was a decision taken on less than good information, right? So you all can control that in terms of managing risk around getting the good information and taking the time you need for good deliberations. All right, let's pivot just a little bit and talk about transparency related to risk. I don't want to spend too much time on this, just to be respectful of your schedule here. You've already been trained, right, on the core requirements of the open meetings law, right? We all know that whenever 3 or more members of the board meet to discuss public business, that has to be a meeting open to the public, right? Some of the interesting things going on around the claims that we see or handle at CIRSA, or they're going on in the courts. Here's an interesting risk management angle from a litigation claims perspective. The Colorado Supreme Court, Court of Appeals has recently confirmed that just about anyone has standing to bring a claimed violation of the open meetings law, which sounds a little counterintuitive, because you may face a risk where someone is saying, well, I don't think the town board followed the open meetings law. Well, that person doesn't have to have any connection to the town. They don't have to have any connection to the matter being considered that might give rise to their alleged violation of the open meetings law. And in fact, in our world, in the litigation world of claims, there's a little bit of a cottage industry out there where there are attorneys and claimants located anywhere in the state. And thankfully, we're very transparent. You have a wonderful website. You can watch your meetings, you can read minutes, right? But what that does in the risk world for this little cottage industry, there are certainly people having eyes and ears on how we, right, meet our commitment to comply with the open meetings law, right? So that standing issue is one thing that's going on in the courts, is that, again, it may sound counterintuitive, but the claimant doesn't have to have any stake in the matter in order to sue. And that just confirms our need to make sure we get all those procedures correct regarding the open meetings law. Open meetings law violations, there's no right to money damages. So it's not a big dollar claim in terms of damages to the claimant, right? But it's a pretty high risk exposure in terms of faith and trust in government, right? In terms of the dollars that could be spent in an unsuccessful open meetings law claim, is that the successful claimant is entitled to their attorney's fees. If we successfully defend an open meetings law violation, you're not entitled to your attorney's fees, except in rare circumstances. So it's a one-way fee provision. Sounds a little unfair, but don't shoot the messenger. That's what the legislature said. Okay. And so that's another risk aspect of this. All right. One other hot topic we see going around these days is the openness requirement absolutely is a rule of 3, right? It has to be an open meeting when it's 3 or more members having a discussion. That means that a one-on-one meeting is okay. And we fully recognize that sometimes that's part of the job, not on quasi-judicial matters that we'll talk about later, but sometimes, particularly for the newer members, you may sit down with a coffee with a fellow elected official and build that relationship, get to understand each other. That's wholly permissible under the open meetings law. So 3 or more openness rule applies. One-on-one is okay. What do you think about this dynamic? One-on-one on one-on-one on one-on-one. That's called that can be potentially, they call it a serial meeting or a walking quorum or a daisy chain meeting. Just recognize that's a hot topic. You may have read some of this in the papers, right? The bottom line on the risk issue is this. If in a legal proceeding, a court finds that, and the evidence comes in, that essentially what's going on in your public meeting is a mere rubber stamping, right, of a decision that was reached outside the meeting through a one-on-one series of meetings, such as, well, we all call each other individually and how are you going to vote on this? That's most likely going to be found a violation of the open meetings law. Okay. So we all intuitively know where that line is drawn. You just want to make sure that you don't use serial meetings as a substitute for deliberations and discussions that need to occur in this room in an open forum. Okay. Last thing on transparency piece is recognize that electronic communications could also be subject to the open meetings law. That's a second handout here that I provided to you, which talks about suggestions, talks about how the statute can be triggered by electronic communications. And that's only half the piece of the puzzle, right? A meeting of 3 or more trustees electronically to discuss public business can trigger the openness requirement, right? So follow your counsel's advice on that issue. That's why staff tells you not to hit reply all, right? So that you don't inadvertently walk into a problem under the open meetings law. But recognize the other half of this is that the correspondence of elected officials in any form, right, electronic or written, by and large is a public record. There certainly are exceptions that staff and attorney will advise on when appropriate, but in terms of your managing your own risk around being a public official, my old sage saw is this: don't say in an electronic communication anything that you wouldn't want to say in a public meeting, right? Or read in the newspaper, or in my world, have read back to you in a deposition, right? Because those things can come back to bite you, and it really is a 24/7 job. If that correspondence does relate to your duties as a public official or does relate to public funds, it could be subject to release under KORA, and in a litigation context, it could be subject to discovery, which is much broader than the public records law, okay? Unless there, I'm sorry, one last piece on transparency is executive sessions. Just make sure you're following staff's advice and support on how you call and conduct executive sessions. There's a lot that you have to do there, but use a script. Make sure you check all the boxes. From where you sit as the board members in managing that risk, I think it's all collectively, we just keep our ears open when we're making that motion to go into executive session and make sure we checked all the boxes, and staff's there to support you on that. Your piece with respect to your fiduciary obligation is to make sure that you have appropriate systems in place to protect confidential information, right? Whether it's in written form or it's a discussion that occurs in an executive session. For example, a good tool that we suggest around that is, let's say you're having an executive session for a matter subject to negotiation, right? Before you exit that executive session, whether it's the mayor or whoever is leading the discussion, a good tool around that is to say, all right, before we break from executive session and go back into public session, of all the confidential information that we've discussed during this executive session, which information, if any, leaves this room and who's our spokesperson? And that's a good, simple tool for the Board of Trustees as the fiduciaries to get on the same page about the confidentiality of the discussion that you've just had, right? Maybe the determination is we don't have anything to share at this point, right? It's a matter subject to negotiation. We can't share anything. Let's just hold our cards close to our vest. One of the things you can do in terms of building faith and trust is, though, when you go out into public session, maybe you can make an announcement and confirm that the executive session was for a matter subject to negotiation. And hey, public, if our negotiation strategy gets any traction, there will be a future agenda item at which there'll be an opportunity for public discussion. Then they know you're acting in their best interest. But even if you voted against going into executive session, even if you can't stand the underlying item that was discussed in executive session, as legal fiduciaries, right, you're obligated to protect confidential information as identified by the board. Okay. Is there any questions about transparency stuff? No? All right. Let's pivot and talk about the legislative versus administrative distinction. We have more information about that in a couple of chapters in the handbook. The idea here is that within every municipal corporation, everybody's got a job description, right? And it translates to risk because you're protected as elected officials as long as you're staying within the scope of your employment, right? And not acting willful and wanton in a willful and wanton manner, which I could talk about if you want, but I skipped that for purposes of this discussion. What it really means, right, is in terms of role discipline and managing your own risk, You have to recognize that the governing body, the Board of Trustees, is the legislative and governing body of the municipality, right? And your manager, by your own design, by your own organizational structure, is responsible for administration, right? So there truly is, although I don't dwell on it too much, there truly is a distinction between legislation, right, or the legislative arm of the organization, that's you, and the administrative arm of the organization. I think it then requires that you all individually and collectively as the board ask, where do we focus our efforts in terms of staying within our scope of employment, our job description as the board, right? And I would commend to you that it's probably within the upper two bands, right, of the graphic here on this slide, right? The Board of Trustees is that part of the organization that's uniquely positioned to be the ambassador, the eyes and ears of the community needs, right? You think about it, what's one of your primary roles, right? To provide a place and a forum, this room, for citizens to come and talk about the needs and wants of the community. And then you're positioned to help determine at that governing body level, how we put governmental resources on those needs and wants, right? But in terms of this legislative versus administrative distinction, it means that the Board of Trustees should have the longest time horizon for the organization. You're thinking, right, where do we want the community to be in 3, 5, 10 years? The important documents for you are the things like the annual budget, right? And not a specific pay stub in terms of fiscal fiduciary responsibility. Looking at the master plan, overall long-term utility planning, visioning for the organization, right? And addressing corporate matters that are reserved to the board, like decisions involving assets, right? And then, of course, quasi-judicial decisions reserved to the board, right? In terms of dealing with the chain of command, we'll talk about that more in a second, right? But as the governing body, you all agree that you're not the supervisors of all employees, right? The board itself supervises how many folks? One, maybe a few more than that. The manager, the attorney, the judge, who just left, so he didn't have to hear that. Right? Is that it? Any others? Yeah. Yeah. Under your organizational structure, you probably have those 3 direct reports, right? And then you as a board have delegated responsibility for supervision below those levels to the manager and supervisors below the manager. Some of this concept is codified in your town code. There's a section there, 2-3-120, that says, except for the purposes of inquiry, the Board of Trustees and its members and the mayor deal with the various departments through the town manager, and that the Board of Trustees, its members and the mayor and board committees shall not give orders directly to any subordinates of the manager. And what that is really doing is it's confirming the delegation that you as a board have chosen to make that says, manager, you and your supervisors are responsible for personnel issues. From a risk management perspective, I would tell you that's a wonderful place to be for you all individually and personally, right? Because it said on the ballot, it said trustee, fiduciary, policymaker, member of the governing body. It didn't say HR manager, right? And in my world, employment practices liability risk is pervasive, right? So you as a board want to use that system for your support and protection, right? We'll talk a little bit more about what that means. But wrapping up the concept of the structure that you've got is to remember, excuse me. Sorry, I lost my thought for a moment. That you have a board manager form of government. The board's the legislative and governing body, and the manager is your chief administrative officer. That means by statute and by ordinance and by your own organizational structure, there are certain duties performed by the board and certain duties performed by staff. And those allocations, they help kind of define not only your structure, but they define scope of employment for you all as well. And that's a good thing, because it frees up, right, your time and resources to deal with things that only the Board of Trustees, right, is set up to handle, right? You want to avoid redundancy. And unlike other parts of the organization where, you know, if necessary, you can have an interim department head, there's no such thing as an interim Board of Trustees, right? There's only one board, and only one board can do the board's job. And that's where you want to focus your efforts and energy. Okay. All right. Oops. The idea of the legislative administrative function, right? It doesn't mean that we're silos, right? And as elected officials, it doesn't mean that administrative matters are strictly, right, hands off. You're entitled to ask questions and get information if you have a question, but you want to do that consistent with role discipline, right? To avoid entanglements or inefficiency or misunderstandings or even potentially exposure to legal liability, right? At CIRSA, probably the main risk exposure we see around scope of employment for elected or appointed officials is an elected or appointed official, misperceiving that they have some authority that they actually don't have, and then individually throwing on that purported cloak of governmental authority and getting overly involved, improperly involved in a personnel or administrative matter that's actually been assigned to staff, right? But if you have questions, right, who's your resource and point of contact for you? Yeah, just like in a private corporation, your CEO is the governing body, right? Your point of contact and communication is with your town manager, right? Okay. This distinction is particularly important in personnel issues, as I've been talking about here. It's not that a governing body doesn't have a role, but its most appropriate role is for the board at that level to stick to the big picture stuff in personnel issues. I don't know if all the ones listed here on this slide are ones that you deal with, but the examples are the governing body's role with respect to the personnel or administrative service of the organization is things like determining the overall departmental structure, right? Dealing with general personnel rules that apply to everyone, dealing with entity-wide pay and benefits. Yes, selecting and managing your direct reports, right? But not others. And then helping establish entity-wide departmental goals and policies. It's just simply the case that governing bodies do their work in public, and you as a board have already delegated responsibility for personnel matters to the manager downstream of that. So the more you become involved, right, if you become inappropriately involved in the intricacies of a personnel matter, the harder it becomes to navigate the competing interests of being on a governing body that has to do most of its work in the public setting, right, versus the privacy rights of individual employees. So just a few more thoughts on that, because I'm not naive around this issue. Before I joined CIRSA about 6 years ago, I did what Marcus did for many, many years. And I know sometimes as an elected official, there might be a little bit of a tug, right, on you. Maybe a citizen had an interaction at town hall that didn't go the way they thought. They got an answer they didn't want to hear. And from that citizen or constituent's perspective, who are they going to call? You, right? And they're going to ask you to get involved, right? You want to think seriously about whether that's something that you should be getting involved in, right? If a citizen comes with you with a question about, well, I got this decision, or the building official told me I couldn't get my permit, and they're calling you, there's an expectation that they want you to get involved. But you have to ask yourself, is my getting involved, right, consistent with our organizational chart? Would it be disempowering the people who we actually assign to make the decision, right? Would I be putting myself at risk, right? Is this an attempted end run around the organizational structure that we as a board have collectively decided upon? And those are all considerations in that issue, right? So again, it's not that, and you are kind of an ambassador of the organization. It's not that that citizen doesn't deserve, a response, but I think in the light of that, if you sense and know that someone's attempting to improperly conscript you or help them with an end run, then your resource and point of contact is the manager, right? That citizen made that call or sent you that email. You can send that over to Helen and her team, and Helen says, I'll take a look at this. And as elected official, you can say, hey, I got this inquiry from a citizen. Would you please look at this? It's an administrative matter. And then your manager will say, I got it. I'll look into it. I'll get back to the citizen. If requested, I can report back to you, elected official, on what the outcome was so that right, wearing your ambassador hat, that you're prepared to respond to that constituent next time they bump into him on the street, right? Hey, did we get you the information that you needed? What if the answer is no, if it's a persistent no? Then you really have to ask yourself, well, is this person looking for an answer that we as an organization can't give them, right? And again, connect them with your manager who can help explain, right, what's going on behind that administrative issue. Okay. Let's see. Last thing is a couple of tips around board staff relations with respect to the legislative administrative distinction. Recognize the perceptions and impacts in getting involved in matters that are delegated to staff, right? Right. You do hold the most powerful positions in municipal government, right? And it's not that we're not, friendly. We can be collegial, and we certainly probably say hi to department heads and other staff and so on. But recognize from that perception, even a comment from an elected official that's something like, "Hey, I'd like to see this happen." If that communication is going to someone below the level of the town manager, right, it might create a perception or have an impact that we may not be fully attuned to. You have every right to say to the manager, "Hey, I'd like to see this happen." Of course, your manager is going to help manage the inputs that she's getting from all of the trustees in terms of trying to figure out, well, this is a matter that's got to go to the board for the board to decide whether they want to spend energy and resources on this issue, right? So make sure you have a good system in collaboration with your manager for bringing forward administrative questions and concerns or those raised by citizens. You actually have in your board adopted rules of procedure, there's a rule in there, Rule 9E, which very nicely kind of lays out your collective expectations that you approved as a board about how you deal with those kinds of matters in terms of citizen requests for assistance and so on. So take a look at that and, commit to using that not only to help the organization function efficiently, but also to keep you out of harm's way, because it truly is. I admittedly see the downstream end of bad situations because that's what we do. We deal with claims. But there can be a risk if someone, without being fully transparent with you, is attempting to conscript you into some area, getting involved in some area where for your own risk management would be better off not getting involved. Okay. On the other hand, with respect to your direct reports, commit to speak as one boss, right? That doesn't mean that it's always a 7-0 vote. It's just whatever the voice of the board is, however you get there. But the board itself, right, is the supervisor of your direct reports. And so you want to, you know how it is. Sometimes there's a discussion and the mayor says to the board, "Okay, that was a nice discussion, board. Let's give Helen some direction." And you go down the dais and you got 1 idea, 2 ideas. You got 7 different ideas of what the direction ought to be. Is that when we turn to Helen and say, "Helen, you got your direction?" But who owns that issue? You do. And you want to because you're the boss, right? But you have to commit with each other as trustees to work that out, right? Whatever that looks like to you. Sometimes the mayor will recognize, well, this is kind of intractable this evening, but let's bring it back so that we can work it out. And that's how we speak with clarity and credibility to our direct reports. Okay. Another aspect of liability risk around organizational structure relates to personal conduct, right? In service of your fiduciary responsibility, commit to high levels of personal conduct. Being on a multi-member governing body, we absolutely, each one of us, right, is asked to contribute our own voice, our own experiences, our own perspectives. But at the end of the day, a board of trustees speaks with one voice, right? And it's the voice of the board, whether it's expressed in a 4-3 vote or a 7-0 vote. That's the one that affects action, that formulates the position of the board. And so sometimes I truly believe that being on a governing body sometimes is going to ask of you that you commit to certain types of personal conduct that help strengthen the institution of the board of trustees, even though it may be personal conduct that we prefer not to have to do, right? Here are some examples, things like setting aside a personal agenda or interest when there's lack of support. And may have run for office on the idea that I want to be on the board of trustees because my only interest is to make sure that we have an ordinance that prohibits this or allows this. But if I don't have 3 other members willing to come along, right, I have to be willing to shelve that personal interest or agenda in service of the work plan as identified by the board. You do have to be willing to accept that the board has spoken, even if you had preferred a different outcome. You have a 4-3 vote. You're on the losing side of that vote. You don't have to be the number one cheerleader of that decision, but certainly from a risk standpoint, you cannot, as a fiduciary, do things that undermine that decision. I'll give you a real life example of that in a claim situation. Had a very close vote on a development. It was a 4-3 vote, right? And in an unnamed jurisdiction, the mayor was on the 3 side of the 4-3 vote. And the effect of the approval was to allow the development to proceed. You know, they were done with the board process and now they were allowed to go to the building department and get their permits. Well, the mayor who was on the 3 side of the 4-3 vote went later on to the building department and said, hey, by the power vested in me as mayor, I direct you not to issue building permits for that project. Good idea? No, you know, sometimes it's not that black and white, but you know, other situations is if you approve something as a board and it's a contract, even if you didn't like that contract, you can't do things that interfere with that contract, right? That disparage that contractor or what have you. You have to just respect the decision of the board as expressed by the board itself. Respect the board's rules of procedure. I mentioned that you have rules of procedure there that are very helpful document in helping framing roles and expectations. The last bullet I want to mention just real quickly. Do you agree with this notion as elected officials, particularly in this day and age? It seems like, you know, you're under so much pressure. People want to know tomorrow's news yesterday. Do you agree? Like, when's the board going to do something about this? Or what do you, right? I think it's a wise board and wise individual members of a board who have their radar up. Yeah, you may be asked for your personal opinion, and I fully get that you have every right to express your personal opinion on some policymaking issue. But in terms of making the Board of Trustees stronger as an institution, right? It's keeping your antenna up for the idea that if I jump in now, will there be a perception, right, among the citizens or that group or what have you, that I might be getting ahead of or purporting to speak for the board itself has even had a chance to speak, right? The way sometimes we have a liability hotline at CIRSA where sometimes elected officials call me and they say, here's the frustration I feel around this issue. I thought that we as a board were going to have our discussion, we're all equals on a board of trustees and we all bring our own voices. We all have a safe spot for deliberations. We each say our piece and then we make our decision. And they say to me, I thought we were going to have this discussion on this issue for the first time at our work session next month, right? But the frustration that I'm feeling is that one of our members is out there, you know, saying things that are trying to get a leg up, right? And now I feel like I'm coming to this discussion with a foot in the bucket, right? Because we have this dynamic going on where people are, you know, in the eyes of the community are speaking for us before we as the board have even had a chance to develop our own voice, okay? A couple more thoughts around personal conduct and risk management. There's a chapter in our handbook about what we call the outlier syndrome or elected officials going it alone. The way it ties back to some of my earlier comments is the idea, right, if we have to recognize on a multi-member governing body that has a lot of rules on how we do things, it may feel constraining, but we don't have the luxury to say, oh, I'm not going to follow that rule. You all do what you want and I'll do what I do. That can have significant potential liability risks. Other things that people ask us for guidance on every once in a while at CIRSA is things like problem areas include lack of good faith, preconceptions, undue partisanship. You know, in Colorado, by tradition and law, local government is nonpartisan. There's no partisanship stated on the ballot. So, you know, I think we see more and more this idea of federal and state partisanship creeping into local government. And, you know, if you want that to happen, you can allow that to happen. But I also think there are some behaviors occurring at that state and federal level that aren't really translatable to what you do as the corporate governing body of a municipal organization. The other interesting phrase, no one's asked me about it yet, but I'll mention it because I do get the question is, what is proxy talk? And proxy talk is the idea, you ever go to a discussion among a group and somebody says, it's like your first time discussing the issue, or maybe it's a new policy issue for you as the board, and people go to the discussion and somebody says, well, everybody I talk to says we ought to do this. Right? And then, but somebody else on the dais goes, well, that's weird. Everybody I'm talking to says, no, do something else. Right? Or maybe somebody says, well, I don't even know why we're talking about this policy because it's always been our policy that we do this. Those are kind of proxy talk things, right? And it's above my pay grade in dealing with claims, but it is something that elected officials ask us about in terms of rules of conduct and rules of procedure, because the corrosive effect that it has on a governing body is, remember, among those 6,500 residents of the town, you were elected to speak with your own voice, right? Yeah, you're going to talk to your own people and have your own point of view that's developed on your own experiences and perspective, but we're all a board of 7 equals. And coming to the discussion with, this is my voice contributing to our voice, speaking forcefully for your own point of view, right? As your own point of view, I think, right, builds stronger faith and trust in the organization, right? And reminds us that we're all fighting for our own points of view with our own voices, right? Okay. Let's see. Last thing I want to talk about, just spend a couple of minutes talking about quasi-judicial decision-making. And by the, if earlier discussions are any hint, it sounds like you might have some quasi-judicial decision-making coming up with that development project or whatever that was you were talking about earlier. But you probably got a lot of them going on right now, right? Right? Particularly for the new folks, but you all know this, right? Being in local government service on a municipal governing body is very interesting because at certain times you're engaged in legislative policy making, or you're making policy that doesn't affect anyone in particular, affects everybody in general. There's no applicant in front of you, right? And in that policy making mode, maybe you're working on an ordinance to decide whether or not to raise or lower the number of pets you can have on a piece of property. Heck, in that legislative mode, you can make the decision based on your own personal preferences, right? You can lobby people and be lobbied. You can do your own research, right? All those kinds of things that legislators do. That's the legislative part of being a trustee. But at other times, you as a board of trustees are making decisions that affect individual property rights, right? And that's things like land use decision-making, like a subdivision application, a rezoning application. What else do you call them, Marcus? Final development plan, is that what you call it? Something like that? PUD plan? Yeah,
Typically a preliminary plat, final plat.
preliminary plat, final plat, rezoning request, conditional use request, is that what you call it? In those kinds of situations, the Board of Trustees is not acting as a legislative body anymore. It's acting as a quasi-judicial body, making a decision that affects an individual's protected property rights, right? And for you all, that's most commonly land use applications and licensing applications. And in that role, right, you have different requirements that apply regarding your own conduct, both individually and collectively as a group. And you go, well, why is that, right? These quasi-judicial proceedings are ones that require you to basically do the things that judges would do and not do the things that judges wouldn't do, right? And why is this? A quasi-judicial proceeding has basically 4 key elements. It's a situation where you have an applicant in front of you, right? And you give additional notice to the interested parties. That explains why we put those posters out on the property and we put notice in the newspaper. It requires that you hold an adjudicatory hearing, a mini trial. That's what your public hearing is. And that you make a decision as the decision makers based solely on the information that you learn at the hearing through a process of applying your pre-existing legal standards to what you hear during that hearing. That all sounds like a little bit of a trial, doesn't it? An adjudicatory process. And that's exactly what it is, right? It all sounds a little unfamiliar to you, but here's how we ground ourselves in that. In Mead, of our 6,500 residents, at the end of the day, with you and the planning commission, there's only 14 people. If your planning commission is 7 people, is that right? Is your planning commission 7? Yeah. Yeah. Well, yeah, and well, in terms of decision making, it's only 12. So of our 6,500 residents, only 12 people have the power to decide whether or not someone gets to subdivide their property or rezone their property or get a conditional use approval, right? And that's pretty significant power. And with that power, the grand bargain is you as the decision makers are obligated to make sure you're honoring people's constitutional due process rights, right? It all comes from the due process clause. No person shall be deprived of life, liberty, or property without due process of law. So that's the grand bargain. In exchange for that power to say yes or no on these applications, you have to follow the quasi judicial rules of engagement, okay? So some of those rules of engagement, I'm sure you've been coached on before, but just to go through them from CIRS's perspective, some of the key ones. It requires that you as trustees limit your involvement in that quasi judicial matter to just the town board public hearing. Right? You want to wait till the matter is ripe for you as the board to hear the matter, right? No matter how much, and I know this is difficult because what happens when you have a high profile or controversial development application? Maybe there's a story in the newspaper about it, right? And what do your constituents want to do? They want to call you early and ask you, talk to you about it, right? But you have to hold your powder, right? And make sure that you're not getting involved outside the public hearing. Remain neutral. Don't make up your mind before the hearing. Don't make any prejudicial statements before the hearing, right? That suggest you can't be impartial, right? That comes up, just kind of a glib example. The newspaper reporter calls you and says, hey, I see you got a controversial development coming up next week. How are you going to vote? Well, the applications for whatever, I don't know, a marijuana dispensary. And, when I ran for office, I said I would never vote for a marijuana dispensary as a land use project. That's not an impartial judge, right? So one of the very key aspects is make sure you avoid ex parte communications. Do you all know what that is? Right? That's the obligation of a judge, and your judges here, to avoid communications with interested parties about the subject matter of the hearing outside of the hearing. And I know that can be a lonely part of the job, but when we advise, and Marcus advises you about avoiding ex parte contacts, we're trying to protect your ability, right, to stay in the game and participate at the board level in making the decision. But it absolutely does require that you avoid engaging with people outside of the hearing. So have your talking points ready. You don't, it doesn't, in this day and age, it doesn't happen where you go out looking for it. It's people come looking for you. They'll send you an email or they want to grab you at the grocery store and talk about this land use application, right? You want to just have some talking points ready, something like, hey, look, I know you want to talk about this conditional use request, but I need to tell you as a board member, I'm one of the decision makers. It's not that I don't want to hear from you. We'd love to hear from you, but I can only engage with you at our public hearing. So please come to the public hearing if you can. If you can't, you can send emails to staff and they'll be part of the record, okay? Any questions about ex parte communications? All right, another piece of the quasi judicial process is to make sure we have a good understanding that deliberations matter. It's like, you have your land use hearing where the applicant makes their presentation and staff makes their presentation. Then you have public comment, then you ask any clarifying questions, and then you bring it back to the board for the board deliberation. From a risk management perspective, that is the most crucial part of the hearing, because that's when the board, right, is going to talk about and formulate the reasons for its decision. And what you're really doing, if you like math, is you're in this formula, you're taking the facts you learned at the hearing presented by the applicant, the staff, and the public comment, and you're lining it up against the pre-existing legal standards that apply to this decision. And then you're articulating your decision, right? During your deliberations, the due process clause does require that you set aside your own personal opinions and preferences, right? If it's a subdivision application, the standards for approval or denial are in the staff report, right? And those are the only standards that apply. So you have to be able to set aside extraneous considerations or irrelevant considerations. Do you ever have a land use hearing? Sometimes land use hearings can feel a little bit like ships passing. You know, maybe you've got a controversial application and it's the final step. It's the final conditional use request for apartments, which are conditional use in the zone. And during public comment, people stand up and say, well, I know you're here to do the final plan for these apartments, but my comment is this property should have never been zoned for residential to begin with. Is that the issue under consideration that evening? Right? So when you're deliberating, and even earlier during public comment, you want to, remind people who are presenting evidence to you to give us evidence that relates to the relevant legal standards that we have to apply to as a board. That's what's most helpful to you, right? Is to remind folks of that. You also, as the board, have to weigh the credibility of evidence and speak to the standards that apply. That can get a little tricky in a couple of areas. What if you have, let's see, you probably have, like, as part of conditional use requests, a standard or criteria that relates to traffic impacts, something like that. I'll just give you a quick example, right? Yeah. Sometimes, what you'll have is the applicant, maybe you got a standard in the criteria that says the development shall not unduly disrupt traffic or the functionality of an intersection. And you got an applicant who gave you their testimony on that. You got staff that said, yes, we've studied the traffic impacts based on the traffic methodology used by traffic engineers, and both the applicant and the staff say there will not be a traffic impact that makes this unacceptable. But all the people during public comment say, hey, I use that intersection all the time. And if you approve this development, that intersection will be absolutely unbearable. So I urge you to vote no. As the quasi judges, what do you do with that kind of information? What do you think? That can be kind of tough because you have a whole group of people who are testifying, vote no, because my opinion is, right, this intersection won't work. But on the other hand, you have your experts, including your staff and maybe the traffic engineer of the applicant, testifying that according to your own standards and methodologies, it will work. Right? As the decision makers, you have to sort out that sort of opinion testimony that's not fact-based from the actual fact-based testimony. And in that situation, you kind of have to, you have to discard that unsubstantiated opinion testimony, right? And look to the credible factual evidence presented by, right, your experts, okay? The other area where it gets a little sticky is, do you agree with this notion that sometimes, and it's a good thing because these are constitutionally defensible standards, but sometimes land use standards can seem a little fuzzy, a little subjective, perhaps? That's sometimes the accusation, right? This seems like a subjective standard. Maybe as an example, one of them in the conditional use arena is something like the proposed development must be compatible with the neighborhood. Or I think the way your code puts it is the development will not substantially alter the basic character of the district, right? As a decision maker, what does that mean, right? How do we get to that issue? It's seemingly quite subjective, right? But I've got a little risk management tool that I think will help. It's called Sam's Rule of Why, okay? And that is just to get granular when you have your deliberations, right? Maybe we've got it, to use an example, we had a nice public hearing on a conditional use for some proposed mixed retail with apartments above or something here in the downtown area. And the mayor says, okay, board, good discussion, good hearing. Thanks everyone for your testimony. Board, it's time to deliberate who would start. Who would like to start? I'll say, Mayor, I'd like to start. I'm going to vote no against this conditional use because I don't like it. Well, we're off to a little bit of a rocky start, right? But we can get there just by using the rule of why. Right? Maybe another trustee turns to Sam and says, well, why don't you like it? I'm going to vote no because I don't like it because it doesn't meet our criteria. Now we're getting somewhere. And we're all looking at the page of the staff report that lists the criteria. And we're also looking at the pages of the staff report that talk about the crux issues. But go deeper. Sam, what criteria are you talking about? Well, I don't like it. I'm going to vote no because it doesn't meet our criteria. And specifically, it doesn't meet our commercial design standards under section 16-2-180 of our municipal code. Are we done? Go deeper. I'm going to vote no because I don't like it because it doesn't meet our standards. It doesn't meet the commercial design standards because, as the staff testified, it doesn't meet our design standards for building facades and for building articulation or other things. Now you've just magically, as a board, by having that granular discussion of the relevant factual information, right, that's been discussed at the hearing, you've now made a record, right, of the defensible reasons. But the flip side of that coin is you have to be able to recalibrate, right, if discussions are going astray, right, if we're talking about irrelevant criteria, or we're saying, I'm going to vote no because this isn't the application I want. I'd really rather see this. You can't do that either. The applicant's entitled to a decision on the application they requested. And you also can't base a denial on things that you would prefer to see in the code or on purely speculative reasons, right? Or on conditions or standards that are not legally enforceable. So for those tough discussions, make sure you rely on your staff to help you with that. From your perspective in managing this risk, it's never inappropriate for you as the decision makers to ask staff, what is this criteria and how do we, because I hear, here's one more example. I hear the applicants saying that they meet the height limit, but I hear staff saying they don't. So what again is our standard for the height limit and how does that work? And then the staff can explain to you the 2.5 pages of the development regulations that talk about how we determine the height limit. Right? Because it's never that easy, right? But they're there to help you and support you and help you make good defensible decisions. Okay. So any questions around quasi-judicial decision making? That's my last handout. It talks more about that role that you all have as trustees. And I just want to get out of the weeds here and aggregate, things back up to just some final closing thoughts. So as I mentioned earlier, recognize that as the elected leaders, right, you hold the most powerful positions in local government, and you help set the tone for the town government, including the tone and attitude of the entire organization around risk management and liability issues, right? At the governing body level, at the corporate governing body level, do the things as a governing body that are within your wheelhouse, right? That help protect the organization against undue risk and that help resource the organization as a whole to enable it to appropriately address risks effectively, right? Use courtesy, tact, and diplomacy in public settings as members and as a governing body, commit to no surprises approach, right? Your meetings ought not to have surprises or gotcha moments or staff bashing, right? Imagine how powerful it is that even if you had a concern about a staff issue, if there's a member from the public, and the mayor queues up public comment and this person comes in and they just spend, what do you get, 3 minutes? Spends the entire time just bashing some member of the staff. Even if you had a concern, imagine how powerful it would be to say, look, we as an organization, and as it says in our rules, right? Our public meetings are not the appropriate place for personal attacks, right? You might have a concern, but you want to express that concern in the appropriate forum, right? Either collectively as trustees, if it's actually something in your wheelhouse, or to the manager, right? Deal effectively with discord. It would be unusual indeed, right? On a multi-member, 7-member governing body, if we didn't have disagreements once in a while, right? But we can have disagreements without being disagreeable. And don't let discord, right, or those disagreements drive how you interact with each other, right, or with the citizens or with the staff. I think the expectation of the citizens around the fiduciary responsibility is that if you have a tough decision, we make our decision and we move on, right, and that everyone recognizes in this environment, I'm going to win some or lose some, right, but we always commit that our deliberations are a safe space where everyone can speak their piece on their particular issue, but do so with courtesy, tact, diplomacy, civility, professionalism, all those things that are mentioned in your board adopted rules of conduct, right? And then finally, aggregating it up to the fiduciary issue, commit always to the service of the town as an entity, right? To taking the time you need and getting the information that you need to help you effectively manage risk, and to committing to the fiduciary and stewardship responsibilities of being on the Board of Trustees. So with that, the last couple of slides are some more resources and information about CIRSA that I hope are helpful to you. With that, I'll open it up to any questions that you have.
Questions or comments for Sam tonight? I'd like to say thank you very much for giving us this training and for all the documentation and this, the handout that is very referenceable. So thank you very much, Sam, for spending time with us tonight. We appreciate it. Marcus, do you have any words of?
Sam, I really appreciate you coming every 2 years, and I think it's very helpful for the board to be reminded about a lot of these concepts. So thank you again.
And thank you all. I should have mentioned this out, but just one last parting thought. Part of being in a pool is that one of the things we get to do is build longstanding relationships with our members. So I want to again thank you all for being longstanding members of the pool. You've actually been in our property and casualty program since 2003, excuse me. And we really value and appreciate your membership in our organization. And we truly believe that collectively, right, as being a resource for you all, right, as much or as little as you'd like to use that, we think it's in service of, municipalities collectively in the town. Our most important interests are only two things: the interest of our members, protecting them against risk and undue liability exposures, and the interest of the pool as a whole. And we are truly all in this together. So thanks again, board, for having me out. It's good to see you all again.
Thank you, Sam.
Thank you.
See you at CML, the conference.
Yes. See
Okay.
you then.
All right. See you.
Thank you.
All right, thank you. We'll move on to the proclamations tonight. The first one is National School Resource Officer Appreciation Day, February 15th, 2025. I've asked Trustee Crane to read the proclamation. Sir?
Proclamation, National School Resource Officer Appreciation Day, February 15th, 2025. Whereas the National Association of School Resource Officers is dedicated to making schools and children safer by providing quality training to school-based law enforcement officers. Whereas school resource officers bridge the gap between youth and law enforcement and embrace the triad concept of school policing, serving in informal counseling, education, and law enforcement roles to support students and the communities that they serve. Whereas by training law enforcement officers to counsel, educate, and protect school communities, the men and women of NASRO continuously lead by example and promote a positive image of law enforcement to school children and school communities. Whereas SRO programs across the globe are founded as collaborative efforts by police agencies, law enforcement officers, educators, students, parents, and communities to create a safe learning environments, provide valuable resources to school staff members, foster positive relationships with students, and develop strategies to resolve problems that affect youth within the goal of protecting all children so they can reach their fullest potential. Whereas school resource officers are valuable and essential members of the education community and deserve unwavering respect and support from the communities they serve in the pursuit of keeping schools and students safe. Now, therefore, Colleen Whitlow, Mayor, do hereby designate February 15th, 2025 as National School Resource Officer Appreciation Day.
Thank you very much. Is there a motion to approve the signing of this proclamation?
I move to approve the signing of the proclamation for National School Resource Officer Appreciation Day, February 15th, 2025.
Is there a second?
Second.
Thank you. Roll call, please. Mary?
Trustee Crane,
Yes.
Trustee Adams,
Yes.
Mayor Pro Tem Harris,
Yes.
Trustee Schranz,
Yes.
Trustee Hagan,
Yes.
Trustee Babcock,
Yes.
Mayor Whitlow.
Yes. Thank you. Motion carries. Chief Newbanks, please, on behalf of the town trustees and myself, please pass our gratitude on to our SROs. They're the best. So thank you. All right, we'll move on to our second proclamation tonight. It's National Engineering Week, February 16th through the 22nd of 2025. I've asked Trustee Schranz to read the proclamation. Sir?
Proclamation for National Engineers Week, February 16th through the 22nd, 2025. Whereas engineers use their scientific and technical skills in creative and revolutionary ways to fulfill society's needs, and whereas engineers work on many major technological challenges of our time, such as rebuilding towns devastated by disaster, cleaning up an environment, assuring safe, clean, and efficient sources of energy, designing information systems that will propel our state and country into the future. And whereas engineering has been called the invisible or stealth profession because everything around us and things we use every day have been engineered in some way, yet we may not see the engineers behind the scenes or know much about engineering. And whereas founded in 1951, National Engineers Week is dedicated to ensuring a diverse and well-educated future engineering workforce by increasing understanding of and interest in engineering and technology careers. And whereas Engineer Week promotes recognition among parents, teachers, and students of the importance of a technical education and high level of math, science, and technology literacy, and motivates youth to pursue engineering careers in order to provide a diverse and vigorous engineering workforce. And now, therefore, Colleen Whitlow does hereby designate the week of February 16th through the 22nd, 2025 as National Engineers Week.
Thank you very much. Is there a motion to sign, is there a motion to approve the signing of this proclamation?
I make a motion to approve the proclamation for National Engineers Week.
I second.
Thank you very much. Roll call, please.
Trustee Babcock,
Yes.
trustee Crane,
Yes.
trustee Adams,
Yes.
trustee Schranz,
Yes.
Mayor Pro Tem Harris,
Yes.
trustee Hagan,
Yes.
Mayor Whitlow.
Yes, and the motion carries. I would like to say thank you to our town manager, who is also an engineer, and our town engineer, Public Works Director, Erica Rasmussen, for all the work that you guys do for us. So thank you very much on behalf of the board. Okay, we'll move on to our public comment. The board welcomes public comment at this time for any item on the agenda, except for the public hearing item. We will also take comments for the items not on the agenda during the second public comment, number 12. Please remember that public comment is not intended to be a question and answer session. The board will listen to your comments and take them into consideration. All comments should be directed to the Board of Trustees and not to a specific individual. If you wish to speak during this public comment period, please adhere to the town's general guidelines. Please start by stating your full name and an address for the record. Each speaker will have 3 minutes to address the Board of Trustees. If you are representing a group, you will have 5 minutes. We ask that all speakers and audience members treat one another with respect and dignity. Please ensure we maintain a welcoming environment and avoid any actions that could be distracting. I would like to back up into my script there. We do not have public comment tonight, public hearing tonight, so I'd like to scratch that from the record. Is there anyone here in the room that would like to speak to the Board of Trustees on any item on the agenda? Excuse me.
Sam Light.
Oh, yes, yes, sure.
Ron Smith, 325 Main Street. I'm glad he spoke tonight and enlightened a lot of things. So he was giving all the perimeters in which the board can act and not act, what their obligations are and what they aren't. I wasn't going to bring this up, but he totally just threw my whole situation out the window. So in 2023 in the midsummer, Scooter Hinge, everybody knows what Scooter Hinge is, was shut down. There's a stop work put on it, and we couldn't find out why. The owners of Scooter Hinge, along with myself, stood in front of some of the people on this board and asked for them to look into everything. What we got was, it's illegal, we can't talk to you. That went on with the mayor and coffee with the mayor. It's illegal, we can't talk to you about it. Helen also couldn't talk to us about it. for literally almost 9 months. That building sat there, nobody would talk to us about it. Nobody on the board investigated that. Nobody went to Helen, as Sam just said, they could have done, and found out what was going on. It cost the owners of that building a lot of money for those 9 months it sat there. And then when we finally got 10 days before the court hearing, I was in the room with the lawyers and with the owners. And the first thing the lawyer said was, let's get this off the table. I show 8 stop works here and 8 violations on your complaint. But yet I don't have a single one recorded. And I said, because there was never a violation of either of those. And there was never 8 stop works. So for 9 months, the board and town manager, nobody responded to the owners or myself when we stood up here or when we got in front of coffee with the mayor and talked to them. Because it's illegal and we can't talk about it. Now, what that man just told us here shows me that the board didn't do their job and the town manager didn't investigate. Instead, the owners paid hundreds of thousands of dollars for that building to sit there and then had to hire a lawyer to fight the town for this whole situation. Absolutely unacceptable. And the person that was the main person in charge of that whole situation is still in charge of the same department he was back then. So according to what that guy just said a minute ago, I think we got some people here that need to answer for that whole situation, including the cost it cost the owners of that building for a lawyer. I appreciate him getting up here and saying it.
Thank you for your comments, sir. Anyone else who would like to speak to the board on any items on the agenda? Okay, seeing none. Thank you very much. We'll move on to our consent. The consent agenda contains items which are considered routine and are approved with one motion and vote. Is there a motion to approve the consent agenda as amended?
I make a motion to approve the consent agenda.
Second.
Okay. Roll call, please, Mary.
Trustee Adams,
Yes.
trustee Crane,
Yes.
trustee Babcock,
Yes.
trustee Hagan,
Yes.
trustee Schranz.
Yes.
Mayor Pro Tem Harris. Sorry.
Yes.
Mayor Whitlow.
Yes. Motion carries on the consent agenda. We will now go to 9E, resolution number 12-R-2025. And for the public, it is a resolution for the town of Mead, Colorado, approving the acquisition lease of 2 fleet vehicles for 2025, utilizing the master equity lease agreement with Enterprise Fleet Management, EFM, dated January 14th, 2021. I would like to turn the microphone over to Trustee Schranz, who would like to ask a question.
Thank you. And it is just a clarification for me question. It talks about Enterprise being a leasing agency that we get police cars from. Is that the same leasing agency that the town uses for all its procurement of vehicles, including public works, trucks and trailers and any other stuff, or do we have independent leasing agencies?
I'm going to defer to Mary on some of the large dump trucks. I'm not sure that Enterprise carries those, but all our passenger fleet or light duty vehicles we lease from Enterprise.
Okay. That's good.
Some
I
of
didn't know
those
if we had
gigantic
people-
ones, I don't think they carry those, right? Yeah, like, you know,
No, I can
Snow
confirm
plows.
that Enterprise is just our passenger vehicles, the pickup trucks, the plows, whatever, but the big plows that we get or the street sweeper that was in the budget for 2025, those are all separately purchased and leased. They don't go through this leasing program.
Okay. Okay, thank you. Well, with that piece of information, and I don't know if this is the right place to do that, but I'd like to see if we can get staff to investigate leasing town vehicle, a vehicle for use for town staff. Is that something you would go through Enterprise to evaluate? A pool. We have one? Right, my mistake. Thank you. That's all I needed.
Is there any other questions or comments for this resolution? Yes.
Are these cruisers? I mean, is that what the lease is for?
I would direct the question to our town manager.
I'm going to ask Chief
Okay.
specifically to
Sorry.
talk about them.
Sorry,
because
Trustee Hagan.
These
Sorry.
are his two vehicles that are up for lease. So
These are two Ford Explorers. So that's mostly what's in our fleet now is, they're called, police interceptors, but they're Ford Explorers.
But you do all the modifications to them or what?
Correct. They come
Within
as
the
a police
lease?
package, which means they're stripped down and then we have them upfitted. To be transparent, we're having some difficulty finding an upfitter that, at the cost we want to pay. I'm continuing to research that. And I'm fairly confident that we'll come to a good resolution on that. But because there's actually 3 vehicles in the budget this year, but until we get that sorted out, we wanted to sort of chunk it out in pieces a little bit so that we could make sure that the upfitting piece was going to come through the way we want it to at the cost that we need it to.
So we're just an estimate of how much that input is once we get the new vehicle, and then if we just turn it around every 2 years, is that why we're only doing leases? I mean, it seems like a lot of money to dump into a car after you get it and then only lease it and not own it.
So we have a 4-year turnover, but I mean, that's if the car is miled out and we've gotten everything we can get out of it. We can keep them longer. So this lease does not restrict us from.
So we can buy out the lease without much law.
Correct.
Much past. Police vehicles are much more limited on the mileage that they can get out of them. Where you and I could get 250 out of a car, no, about 100,000 is, I don't know. I'd let Chief speak to that, but it's not.
The vehicles that
It's
we're
not what you
replacing
think.
are in that 95,000 to 110,000 range.
And does all the equipment just get moved to a new vehicle? Or is it pretty much outdated by then?
It depends on if the model has been changed. So we do have is that a 2021 that comes up this year? That's the first one that's that 4-year lease. There is a possibility that we reuse some of the equipment out of that vehicle, but the other vehicles we're getting rid of, a couple of them are 2011 Expeditions. That equipment's not fitting in any new car. So it's kind of dependent on whether it can be reused or not. The police radio, the Motorola radio that are $6,000, $6,500 a piece, we reuse those radios until they give out pretty much. So it just depends. There's some equipment that can be reused. The radar units can usually be reused with a new harness, wiring harness, that type of thing. But cages, in particular, if they change the design of the vehicle, it's not gonna, it doesn't fit.
Got it. Thanks.
Okay, any questions or comments on this resolution? Okay, is there a motion for resolution number 12-R-2025?
I move to accept resolution number 12-R-2025, a resolution, Town of Mead, approving the acquisition lease of 2 fleet vehicles for 2025 utilizing the master equity lease agreement with Enterprise Fleet Management dated January 14, 2021.
Thank you. Is there a second? Is there a second? Okay, sorry. Roll call, please, Mary.
Trustee Hagan,
Yes.
Mayor Pro Tem Harris,
Yes.
Trustee Schranz.
Yes.
Trustee Babcock,
Yes.
Trustee Crane,
Yes.
Trustee Adams,
Yes.
Mayor Whitlow.
Yes.
Thank you.
Thank you very much for the discussion. Resolution number 12-R-2025 is passed. Thank you. We'll move on to old business, resolution number 8-R-2025. This is the resolution for adopting the Town of Mead Public Records Request Policy, and I will turn over the microphone for Administrative Services Director, Mary Strutt.
Thank you, Mayor and trustees. This is for resolution number 08-R-2025. which was brought before you at the last meeting on January 27th. It had to do with the public records request policy, the 2025 policy. We were asked to bring back the old policy that wasn't in your board packet last time, so the 2014 policy was not in your packet. So I have the 2014 policy in your packet today, and I'd like to just go through it quickly and go through some of the changes from the 2014 policy to the 2025 policy. Basically, I worked with the Deputy Town Attorney, Lori Strand, on this policy, the 2014 policy, which you'll see is pretty bare bones. We looked at other policies from Fort Collins, we looked at Golden, we looked at Commerce City, we looked at Durango, we looked at Littleton. We looked at about 10 or 12 different cities and how their policy is written to make sure that ours is pretty much user-friendly. Our policy that was written in 2014, which starts on page 45 of your packet, is kind of a cut and paste out of the Colorado Open Records Act. So you'll see the first part with the definitions. That's actually just cut and paste right out of the Open Records Act. And each section gives you what it was copied out of the Open Records Act. What we tried to do with the new policy was make it a little more user-friendly and explain to people who are reading our policy what an open record is and how you can get access to the records. Again, all of our records are open to the public for inspection with very few exceptions. So again, page 45, you can see the CRS quote there where it came out of 2417-203, and it's just copied right out of the policy or right out of the statute. Same with the next on page 46, copied right out of the statute. The only part that's really a policy that I would call it is number 4 on page 47 of your packet, which just says that the records are in the custody of the town and that they're open for inspection. And then it goes on to give you the fee schedule. The fee schedule is in statute also. So again, a lot of this we're just copying from statute, but we wanted our policy to be, again, a little more user-friendly and explain what a public records request really is. So Town Attorney Lori Strand did take the policy, and she, on page 50 of your packet, she annotated the policy so that you could see directly where it came out of the statute. So hopefully those comments answer your questions on the policy. But again, it was to write a policy that gave a purpose, did give the definitions, updated the definitions since 2014 because there have been some legislative changes that affected Cora since 2014, including mostly electronic records kind of things, like we have to release them in an electronic format if we have them in an electronic format. So those kind of things are in the policy. But we also wanted to include right in here what's limited on public records requests. Again, these are all right out of statute. So it's not the town of Mead saying, I'm not going to give you something. I'm going to comply with the Cora statute as it's written. And we'll, again, part of the policy, number 5, page 52, tells the residents of Mead or any citizens of Colorado or anywhere actually, how to request an open records request. There's a form on our website. They can send me an email. Whichever way, we'll take them, we'll respond to them. And then on the next page, it talks to the time frame for response. And then it talks about fees and costs. Those fees and costs are set by statute. Statute says that it's 25 cents per page for copies. It also says that the first hour, there's no charge for the first hour. And after the first hour, we can charge $41.37 per hour. That $41.37 per hour is the new rate set by the legislature on July 1st of 2024. We can't start charging that rate until we approve a policy with that rate in it. So for right now, if we charge anybody, we are charging at the old rate of $33.58, unless this policy gets approved by the Board of Trustees. So that's the public records request policy. Again, we were just trying to make it a little more user-friendly, explain it a little bit better to the public. Are there any questions that I can answer about the policy?
Questions, Trustee Adams?
So Yes, speaking of making it more user-friendly, I'm looking at, and the reason I brought this up too was under page 2, under section 4, limitations and exemptions for public records request. You've got in here in just under paragraph C, examples of other public records that may be exempt from disclosures, including you've got some election, library, and museum records. Again, it's very vague. It's not broken out very well. I went onto the website for the Colorado State, and they have broken it out very well. We have it broken out very well under what the fee structure is for the core request, but we don't have things like this broken out very well. So that is my concern, is just I would like to see it better explained for transparency, just kind of more like what the state has. You see that?
I'm sorry, I'm not
Page 2?
seeing what page you're on.
Page 2,
Uh-huh.
under the section 4, limitations and exemptions for public records request. Yeah, you go down to C, it's at beginning, it's actually at the top of page 3.
Oh, okay.
Examples of other public records that may be exempt.
So at the top of page 3 where it gives,
Section 10, under public records request.
So trustee Adams, just to be clear, it's the language that says, in addition, the official custodian will deny inspection of public record. If C, disclosure is contrary to the public interest.
Yes.
For example, the official custodian will deny the inspection of electronic mail addresses, telephone, and home address provided by a person to an elected official for the purposes of future electronic communications to the person from the elected official.
So that bottom statement refers to that as being the some election requirements. That's what would be withheld.
No, that doesn't have, that's not, doesn't really have anything to do with an election.
Okay.
Record. That's just, the statutory site is provided right there. That's under 2472-204.
I see what, I actually just found what trustee Adams is referring to. Top of page 3, so page 52 in your packet. Page 52 in your packet. Okay, there's a bullet point. There's C and then there's a bullet point. And that bullet point says, examples of other records that may be exempt from disclosure include. Correct, trustee Adams? Is that what you're
Correct.
reading?
Yeah.
Medical, psychological, sociological,
Yes.
scholastic. I mean, we can certainly expand on that and list more exclusions if the board wants. We do reference the section of the code there. So we do give many examples of what's excluded, like psychological, sociological. The election records that are excluded are generally like there's some voter records that are specifically excluded. And those are all listed in 2472-204.
And the same thing with
which is
the
why we
library.
reference, pardon me?
And the library, again, it was under library, it's election, library, and museum records.
Right. And
So-
since we don't have a library or a museum,
Okay.
we did decide to just kind of lump that.
Okay, and that was my concern. It was just lumped in there, kind of just as a big, could be anything. And I just wanted to make sure it was very clear as to what it is that we are excluding.
Yeah, well, and so the last sentence there says see Cora 24-72-204
Right.
for more information on the exempt public records. So if somebody requested an election record, for example,
Okay.
that was exempt under 2472-204,
Okay.
the response from the clerk's office would be that election record is specifically excluded from release due to 2472-204, and I would actually cite exactly where it is in the statute
Okay.
as to why it was excluded.
Okay, that's what I wanted to see. Okay, thank you.
Any other questions for Mary tonight? All right, seeing none, is there a motion for resolution number 8-R-2025?
I make a motion to approve resolution number 8-R-2025, a resolution of the town of Mead, Colorado, adopting the town of Mead public records request policy.
Second.
Thank you very much. Roll call, please, Mary.
Mayor Pro Tem Harris,
Yes.
trustee Schranz,
Yes.
Trustee Babcock,
Yes.
trustee Hagan,
Yes.
trustee Crane,
Yes.
trustee Adams,
Yes.
Mayor Whitlow.
Yes. Motion passes for resolution number 8-R-2025. Thank you for the discussion. We'll move on to our new business, resolution number 13th, 2025. And this will be presented by our town planner, Colin Morales. And this will be approving an agreement for professional services with Logan Simpson Design for service related to our Trails and Open Space Master Plan update. Sir, you have the podium.
Perfect. Thank you, Mayor, trustees. Great to be in front of you again. So yeah, as the mayor stated, the town is looking to enter into a professional services agreement with Logan Simpson for matters regarding the Trails and Open Space Master Plan update. So tonight, I'm really going to give you kind of an overview of what the Trails and Open Space Master Plan is, what we're looking to do with it, and some timelines of where we're looking to go here. So really the main purpose of the Trails and Open Space Master Plan is to guide the current and future development of the trails, open space, recreation, and park systems within the town. So there's several different ways that this goal is accomplished within the plan. The first of which is identifying what recreational opportunities the town should develop, as well as where those amenities should be located. So a lot of that is typically accomplished through community outreach and community engagement. So as I'll discuss later on the timelines, we're looking to do community outreach through pop-up events, open houses, a community-wide survey, to really find out from the community what they would like to see moving forward and what they like currently or don't like currently about the parks, trails, and open space systems. So there's also significant statistical analysis that goes into that as well, such as using maps to identify accessibility, walkability, bikeability within town to these different amenities, and from subdivisions, neighborhoods into downtown and main community gathering areas. So the master plan will also our current master plan and the future master plan will also contain detailed design guidelines for what trails, parks, and open space need to look like when they're included in a development. So this is largely included just to ensure that all recreational amenities, whether town-owned, developer-owned, town constructed or developer constructed, they all are uniform and of the highest quality, whether within a town's jurisdiction or developer metro district jurisdiction. So the master plan will also identify future departmental needs to accommodate the proposed recommendations and strategies that come out of this plan. So as the town grows, more trails, parks, open space are implemented into our system. We'll need to analyze if departments need to grow or shift focus in order to upkeep and maintain these facilities. And so then the last item up there, second last item, the master plan will also identify possible funding mechanisms for implementation of this plan. So obviously, as you know, as a small town, we need to be able to leverage grants, partnerships, et cetera, with other organizations to make sure that we're, really making do with the budget that we have while still providing high quality services and amenities to the town and the citizens. And then the last item that this master plan process is going to address, we're going to take a look at the comprehensive plan and the future land use map and make sure that any goals, strategies, recommendations that come out of the parks, trails, and open space plan align with the comprehensive plan as well. So really just making sure those two documents are congruent with one another. So with this master plan update, one question I get quite a bit, why now? Why are we looking at this now? So our current open space, parks, trails master plan, it's from late 2011. So, it's going on 13, 14 years old. Times have changed since 2011. We've seen a lot of development. There's a lot of development on the horizon as well. So it's good to get in there, see what's worked well with the development that's come in, and then what we need to change to address the future development as it comes. We've also seen some missing linkages between developments, parks, and downtown. So part of this trails plan, trails, open space, and parks plan, we're looking at how to better connect, different trails and such that have come online with developments, but kind of just stop where they're at and they don't connect well with the rest of town. And then also, the town went out for a grant with CDOT, and we were awarded $225,000 in grant funding to help with this project. So this makes up a majority of the budget that we have for the project. So it's a great time right now with the $225,000 from CDOT to implement this project. And so then as far as the request for proposals and consultant selection is concerned, so we put an RFP out back in early December. We received 7 proposals. We shortlisted 3 firms for interviews. Ultimately, we decided to go with Logan Simpson. As you see, our professional services agreement with them is in the packet. We felt that Logan Simpson had the best proposal and the best ideas for how to tackle this master plan. We've also worked with them in the past. They completed our 2018 comprehensive plan, so they're familiar with the town. They've worked with a lot of small towns up and down the Front Range on similar projects. So we're really comfortable with what they can provide and what they can offer for their town. So then here's just a basic timeline and some milestones that we're looking to hit with this project. We're hoping to kick off the project here in March. So we'll have a public open house in the early spring, which is going to introduce the project, and then kind of start that community engagement process of identifying the needs, preferences, challenges, and such with existing facilities and amenities. And then also see what the community wants as far as new trail connections, parks, open space, and the likes. So then during the spring of 2025, so this year, the consultant team is going to start working on looking at existing conditions of all the town's facilities, and then also doing an analysis of all the existing plans and how they relate to parks, open space, and trails. So this is just going to help that consultant team better understand the opportunities and challenges that already exist within our current system, and then how to leverage those moving forward. So during the summer of this year, we're looking to the consultant team and the staff as well. We'll be working on a community needs assessment to understand, like I said, what the community needs are, and then where the parks, open space, and trails are most needed. We're also going to do pop-up engagements throughout the summer and try to tag along with town events as well, since people will already be coming out for those events to get more outreach and feedback. And then during the fall, the team will be working on identifying goals, recommendations, and strategies for moving forward with parks, open space, and trails. So this could include, new locations, as well as improvements to existing facilities, as well as open space preservation strategies. And then this will also contain some budget and financing analysis as well. And then in the winter, they'll be looking to kind of put all of this together in a draft plan. We'll hold another public open house during the winter. We'll make the plan public, people can comment on it, and then we'll bring it to you as well. You guys can make comments, bring up concerns and such. And then we're looking to take that feedback and come up with a final plan and bring it forward in the spring, early summer of 2026. So the board's role in this master plan, you're ultimately the body that reviews and approves the master plan. You'll also be advising staff and consultant on the strategic direction of the master plan. So we'll be coming to you with periodic meetings for review of, the needs assessment, results of community engagement, the preliminary recommendations, as well as the draft and final master plans. So with that, I'm open for any questions. And then there's also a motion in your packet regarding the PSA.
Thank you, Colin. Questions or comments? Okay, I will. Trustee Trans, trustee Babcock, sorry.
Colin, thank you. I'm making an assumption here. I need you to correct me if I'm wrong. These trails, are these the same as the walkways that go through most of our neighborhoods?
So the trails are largely the regional trails. So they wouldn't be necessarily the ones that go within your neighborhood, but that connect the neighborhood to other amenities within the town. So some, they do kind of weave through the development, but they're a little different than what's installed by the developer, just for inner neighborhood connectivity.
That didn't help.
They connect.
Because I'm trying to, I think I'm trying to get specific, because there are some neighborhoods that have walkways going through them
Mhm.
that at one time I believed was part of the trail plan, but maybe not. But my concern is that some of those are owned by the individual subdivision.
Yes.
And at that point, do we have any jurisdiction over that if it's owned by the subdivision? If we want to make changes, can we do that on their portion of the trail?
So the trails we're talking about are town owned and maintained. And then the trails that you're talking about, yeah, are owned by the Metro District
Not all of them.
of the subdivision. But so, yeah.
Some are.
Mhm.
Some are town owned and not town managed.
Mhm.
But I don't know if those are the trails that we're talking about. I mean, there's a lot of concrete that goes from north to south. And I know because I ride my bike down them, but I don't know if that's the trails we're talking about. If it is the trails we're talking about, then I'm confused because there are Coyote Run, Valeview own their piece of it. And I don't know what jurisdiction the town has on making any changes to those trails.
So yeah, the jurisdiction within the development would largely be during the review process. So you know, we review their open space and their trails that they're proposing at the time of development, and then they would construct and maintain those and own those moving forward. But that's for inner subdivision and inner neighborhood trails. The trails we're talking about are more regional connections throughout town.
Can I assume that I'm not talking about the same trails?
I believe you can assume that.
Okay.
I think, I just to make the distinction, what Colin's referring to are, we have a category that's a regional trail designation versus what you're talking about. And they can appear to be like there are trail systems that connect neighborhoods. In some cases, they're owned by metro districts. In some cases, they're town-owned. In some cases, they're homeowner-owned. You know, they're actually in town right away. But what we're talking about here is kind of a larger scale of connecting the town. So, for example, the trail that was built with Gopher Gulch, that's a regional trail. It connects County Road 5 and then it runs basically parallel to Highway 6. It'll ultimately connect up through the waterfront development. That's what we're talking about, not the fragmented pieces. Although when our consultant takes a look at it, if there's an opportunity to rebuild or glom onto something that could become part of the regional system, I'm sure they'll recommend that. But I think what you're talking about are more localized sidewalk systems than the regional trail that he's referring to.
That's fine.
Trustee Babcock and then trustee Hag.
So you guys are asking for $314,364, which is in our budget of the 325,000. But we got a grant of 225,000. So does that actually mean we're putting 89,000 in, or does that mean we're putting 540,000 towards it?
We're putting in 89 with a cap at 100. We have 100 budgeted. We're only planning to use 89 of that.
Okay, so then that leads into years ago, we did a huge master plan for our parks for Ames. And we spent a lot of money and a lot of time going to the public and doing the big open houses and getting all these great plans. And we all know what Ames looks like now. So I have a really hard time looking at $325,000 or what will turn into hopefully 90, or like you said, under $100,000 for something that may never come to fruition.
We still have to have plans, Brooke.
I know we have to
And
have
it's- and
plans,
it's
but when we
actually-
already have plans that we put a lot of time, effort, and money into, and nothing happens because we don't have the money. So if we do this, do we have money to, like, this isn't going to connect some of our neighborhoods and things that I think some of our townspeople, like, we have some really good sidewalks, but they don't all connect and go somewhere. And this is talking about just connecting us regionally when we're not really connected inside. And we want to spend, okay, maybe only $100,000 for something we don't have in the budget. So do we have money in the budget when we do this at the end of that timeline to actually do something with the plan?
Well, if I could address that, Colin, if you don't mind. Well, a couple things. If you don't have a plan, then you don't know where you're going.
Yeah.
This is not just to connect to St. Vrain. This is to interconnect the town amongst the neighborhoods and amongst the corridors. And it's also ultimately to connect to other regional possibilities. But I can tell you from our experience of getting millions of dollars in grants, the first question on a grant for a regional trail is, do you have a locally adopted trails master plan? That's step one before they even get into the next portion of it. I can't speak to the Ames master plan because that's about a $9.2 million build out, I believe. And when we did that, we did it in tandem with Highland Lake, and the board made a decision to move forward with the Highland Lake improvements because we were able to do it for $600,000 or $700,000. It hasn't become a priority yet because we shifted and spent about $8 million on this community center. So it was a matter of board prioritization. So I get that people don't like it when you make a plan and it sits on the shelf, but I can tell you a trails and open space plan is the building block for getting grants. You can't go and say, hey, we want money to build 2 miles of trail that doesn't really connect anywhere, and then we don't know where it's going. So that's the purpose of this. We have budgeted $325,000, of which $225,000 is a revenue.
We have a plan. It's old, but we have, I have a hard time. And yes, I totally agree that we did Ames and Highland, and we chose to do Highland, and other factors fell through with Ames that was helping drive Ames. But we also, as a priority, because I was on that board then, said we would like to do a part or a piece and a dog park, a skate park, replace the skate park that we tore out that never got replaced. So I know we don't have the $9 or now $19,000 million that it would take to do what the master plan, but I feel like we did all that work and we did both, and we spent a lot of time and money doing it. And then Ames we did Highlands great. I use it often. I see a lot of townspeople using it, but this is a hard pill to swallow just because we have a plan. Yes, it's a bit outdated. So we have the plan, but it's $315,000.
And we've grown so much since then.
I realize that. And I am a big user. I like to walk and ride my bikes and everything on the trails. So I'm not for the trails. We have a plan. It's outdated. We have grown. But how outdated? It's just a lot of money. So that's it.
Maybe I can add a little color here to help as well. One of the important things that the consultant will be looking at is not only the plan for Mead and how that may have changed over the last 13 years, but they're also looking at the town's master, trails and really, network plan in a regional context, right? How does Mead's plan match up with Berthoud? How does Mead's plan match up with Longmont? How does Mead's plan match up with Firestone? And the reason that's incredibly important, and Helen can probably speak to this more than I can, but a lot of these grants that are being awarded now are multi-jurisdictional, meaning they will be 2 or 3 applicants for a grant coming in and asking for a grant because the project that's being proposed matches up with the master plans of multiple jurisdictions. And one of the important things that this plan will do is identify those regional connection points. And I think that why the plan needs to be updated is that those regional connection points that were contemplated 14 years ago aren't on the drawing board anymore, right? They don't match up with the reality on the ground. So that's the other, I think, important thing is that it's also it's Mead, but also in a much larger regional context. And how do all these multimodal transportation systems work together, if that helps?
And I know that I've asked Trustee Hagan, but I would like to remind everyone that the the trails plan for 26, County Road 26, it's a regional thing that we've been working on. And it's from Firestone, Longmont, us, Weld County have all put in the monies for these regional trails. And another on top of that is because I've worked with Dr. Cog and different organizations that when you have these plans in place, it's easy for those folks to give us, grant us taxpayer money, but we are on a higher ground of getting a grant or help somehow to get these trails done or whatever transportation, whatever project that is. So that's how we got some money for the intersection, community center, all these underpass for 66. So I understand it's a hard pill to swallow, but we have to plan for the future. You do, you really do.
And one more thing, if I could, when we negotiate with developers, if we have a plan that shows a regional connection through their property, it gives us the teeth in the negotiations to require building a portion of a trail. So one of the things is, as we've seen the land develop in different ways in the town, we have to look at the way people get around. And it's one of our basic tools. It's just like our transportation plan that we did as a corollary to our comprehensive plan. It's how we get developers to build sections of 9.5. If it weren't on our plan, they'd say, well, what are you talking about? We're running into the same thing over on the other side of 66, that whole area between 9.5. That's a mess, an amalgamation of roads that run into each other. And we need a plan there. This is the same thing. This would give us a comprehensive plan that would allow us to navigate grants, development, working with our neighbors in Firestone, Berthoud. That's our plea.
Trustee Hagan, sorry.
I agree with it all. I would just like to say that. But first, good job getting whoever got the grant for 225. You said you had 7 firms proposed. What was the price range?
Yeah, I think the lowest came in the low 2s, and then I would say they were all, within 250 to the 315 range.
So we chose the highest?
Yeah, there were 2 firms that came in around the similar price.
Well, that might address, I think, some of your concerns. I think we could probably it's not like, I know there's a lot of meetings, there's a lot of staff time that goes into getting the public input. That's a huge part of it. But the product is you're drawing, on a map. I don't know really like what the capacity of staff is. You're a young guy, you probably have a lot of computer skills. We could pull together an update pretty efficiently.
You think it doesn't work that way.
It actually does. I do a lot of drafting myself, but I just think that maybe we open it up because that's what I've been told. I've been asking questions about input from the public on dog park in the open space over here. Oh, we don't have money. We have a $10 million plan for that space, but we'll never get the 10 million. So why can't we put in a dog park? It's kind of, planning for something and then spending all your money on planning instead of actually putting something in. It's just, I'm kind of with Brooke on this one.
Any other, do you have any questions for Colin? Or just comments? Is that,
Just the question I asked.
okay. Trustee
Um,
Harris.
So Brooke, you weren't at the retreat, so I just wanted to, I wanted to say, one of the things that I brought up at the retreat is that I would really like us to, because we did do that big master plan and then it just has sat there because of other priorities that have come up. And one of the things that I've really wanted staff to work on is a capital projects plan so that we know, okay, we're saving up for this one next and then this one next.
Right.
It's kind of like with the roads, right? Where we have to look at, okay, the road is in good condition, fair condition, poor condition. Okay, we have to figure out, okay, if we put our money at this one, we only have to spend a little bit and then, so maybe we'll put a little bit more of it here but we have to have a plan, right? We have to know where we're spending that and not just kind of hodgepodge. Oh, well, looks like we have enough for this one this year. Let's just do that, right? We have to have a plan. And so I've asked staff to look at putting together a capital projects plan so that we have more of that long range vision. And I feel like this is part of it. Like we can't plan for a park or an open space, buying an open space or whatever, if we don't have this to guide us. So that's my only.
Any other comments or questions for Colin? Sir, thank you very much for your time tonight and thank you for the presentation. All right. Do we have a motion for resolution number 13 R-2025? Yes. Go ahead.
I move to accept resolution 13-R-2025, a resolution of Town of Mead approving an agreement with professional services with Logan Simpson Design Inc. for services related to the Trails Open Space Master Plan.
Is there a second?
Second.
Thank you. Roll call, please, Mary.
Mayor Pro Tem Harris,
Yes.
Trustee Shranz,
Yes.
Trustee Crane,
Yes.
Trustee Hagan,
No.
Trustee Adams,
No.
Trustee Babcock,
No.
Mayor Whitlow.
Next is our second public comment. We don't have any further business tonight, so this will be for items not on the agenda or still on the agenda. We will follow the same guidelines previously stated. We'll call on individuals in the order that they have signed in. Again, I ask all speakers and audience members to treat one another with respect and dignity. Is there anyone here in the room that would like to speak to the Board of Trustees?
Don Smith, 325 Main Street. I know most people don't want me to get up here and talk. I was originally going to talk tonight about, what's it called? Robert's Rules. I guess we kind of format this whole situation after that, from what I've been told. You guys got the ability to change that however you choose to change it. I'm not the only one that gets up here and talks. I've seen other people talk before. Residents get up here and they say something and nobody says anything back. No response, nothing. Mayor says, thank you. Go sit down. Whatever the question is, whatever I present, whatever somebody else presents, you guys just look at us, we talk. 3 minutes, I'm timing myself. And then we have to go sit down and there's not even a, well, we'll look into it or, how about this or how about that? And I understand there's some legal aspects to that. And if you keep Robert's Rules in format, it takes away a lot of liability, but could at least say, I'll look into it, Mr. Smith or whoever, and I'll get back to you. I don't think that's a legal issue or any questions. It can't possibly be that big of a deal. But I would suggest that because I'm not the only one that gets up here. I've read the complaints and I've heard people, and they get up here and they'll say something and nobody says anything. And then we go sit down and nothing's ever come of it. Nobody ever gets back to us. Nobody says a damn thing. So it would be really nice if we could like adjust the Roberts rules for some little bit, just so that there's an acknowledgement that whoever's standing here exists, besides myself. And you guys say something like, thank you, and I'll look into that and I'll get back to it. I'd appreciate it. And I know other people would too. So maybe you guys could discuss that tonight. Thanks.
Thank you, Mr. Smith. Anyone else that would like to speak to the board tonight? All right, thank you. I will now turn it over to our town attorney for our legislative update.
Thank you, Mayor Whitlow, members of the Board of Trustees. I'll try to keep it very brief tonight. There were a couple of bills that I mentioned at the last regular meeting when I did the legislative update on January 27th. Just want to quickly highlight that the one of those bills was the bill that House Bill 25-1060, which is the electronic fence detection system bill that would limit the town's ability to regulate or prohibit electric fence detection systems, many of which include shot components. That bill has now been introduced into the well, it's been assigned by the House to the Transportation, Housing, and Local Government Committee. So they still have not yet held their first hearing on that, but that should be upcoming relatively soon. The second bill that I mentioned last week that I wanted to just give a brief update on was the bill that will make some updates to the Colorado Open Records Act, or CORA. That is Senate Bill 25077. That has been formally introduced now in the Senate and assigned to the State Veterans and Military Affairs Committee. The bill proposes to make several updates to CORA, including a response time extension. So right now, under current law, the records custodians have 3 working days to respond. That would be extended to 5 working days. And then also for extensions due to extenuating circumstances, current law allows a 7-day extension that would be extended to 10 working days. And then interestingly, this would permit similar requests made within a 14-day time period to be consolidated and treated as one for fee calculation purposes. That is a bill that CML is supporting. So I'll continue to keep you updated on the status of that bill. I also wanted to just quickly highlight that the February 10th State House report did come out earlier today. I wanted to quickly highlight 3 bills that are addressed in the State House report. The first is House Bill 25-1044. This is local funding for vulnerable road user protection. So this would permit local governments to impose additional vehicle registration fees to fund vulnerable road users, meaning basically pedestrian or bicyclist projects. So this is viewed as a way to potentially get additional dollars into multimodal transportation projects. That will be heard by the Transportation, Housing, and Local Government Committee this week, specifically on Wednesday, February 12th at 1:30. CML is scheduled to testify in support of that bill. The second is Senate Bill 25002, regional building codes. This is, and I may have mentioned this one last week, but this is the bill that is proposing to form regional technical advisory committees to develop regional codes for factory-built structures or modular homes. And those codes would then supersede local codes that have been adopted by individual cities or towns. That bill has now advanced out of the Senate Committee on Local Government and Housing and now moves on to Senate for second reading. That is something that CML is in a oppose or amend position on. And then finally, this is a bill that has been tracked pretty closely by Ken Fellman, who is in unofficial retirement right now, but Ken and the CCUA have been following this one. House Bill 25-1056, local government permitting of wireless telecommunications facilities. This would require all local governments to process permit applications within 90 to 120 days, depending on the type of permit. And if those timelines are not met, the application is deemed automatically approved. This will impact local government's ability to process other permits in a timely manner. And I think one of the main concerns that has been identified by the CCUA is that because this bill has an automatic shot clock requirement or automatic approval requirement, they're not necessarily linking that to areas of the state that are currently underserved. So even in areas that have good cell service, this would still apply. So it really tends to limit the local government's ability to look at each specific permit and the merits of that permit on its face. So that is also scheduled to be heard this week in the Transportation Housing Local Government Committee tomorrow at 1:30 p.m. CML is scheduled to testify in an opposed position to that. And then finally, I just wanted to remind you again, if any of you are interested at attending the legislative workshop down at the Capitol, that's scheduled for February 20th. And I think this year they're starting with a tour at the state Capitol and then moving on to History Colorado for breakout sessions. So happy to stand for any questions.
Questions, comments from Marcus? All right. How many more days left we have? Anyway,
Yeah.
thank you very much, sir.
Okay.
Next is elected official reports. Any of the town trustees have anything to bring up tonight?
I do.
Sure.
I would just express my general agreement and recognize Don's comments about how frustrating it is to stand out there and try to get any type of feedback and understanding from this board when we don't even, we don't respond at all. I mean, when I came here, when the town was suing us, I mean, I was just flabbergasted that we would be sitting there without any interaction from the people that are actually elected to represent citizens. And I just can't, I think we need to change the rules to open up some discussion. Like you said, some feedback. Thank you. You know, we'll look into this. We can discuss it amongst ourselves or whatever, but to just ignore the topics is kind of belittling in my opinion. So I'd like to discuss what measures we can take to open that up.
I would turn that over to our town attorney.
You, Marcus.
Yeah, well, right now, I mean, I think it's not Robert's rules. I mean, you all don't follow Robert's rules, but I mean, really what we're looking at are the procedures, the rules for public comment that have been adopted. And what those rules say is there's not supposed to be a protracted back and forth dialogue with members of the public that come up. It does not prohibit any of you from saying thank you for the comments or providing direction to the town attorney or the town manager to set up a meeting with that individual to address the concerns. I mean, that that direction from the board really, again, should be directed at staff to look into a specific issue or then follow up with that individual. That's absolutely fine. And you're not currently prohibited from doing that. You're not currently prohibited from doing that.
Okay, anything else? Oh, Trustee Crane.
Are we on the same topic or are we moving to a different topic?
You can say it's up to you.
Okay.
Yeah.
Yes, I have something to report, and this is based off of last meeting's proposal for the psychedelic healing centers. I was able to do a little bit of limited research on this topic, and so here's a little bit of background. Proposition 122 passed in 2022 by the Colorado voters. It allows for the decriminalization, gifting, and administration of psilocybin to individuals 21 years and older. Proposition 122 does not permit cities and counties to prohibit the healing centers or the administration of psilocybin. However, cities and counties may regulate time, place, and manner. Psilocybin, a lot of people know it as magic mushrooms or just shrooms or anything like that. Some of the background on that is 3.8% of high schoolers have reported using psychedelics according to the 2023 Healthy Kids Colorado survey. 4.5% of calls to poison control centers from psilocybin are of children less than 6 years of age. Rocky Mountain Poison and Drug Center has tracked 135 cases of psilocybin exposure during 2024 with ages ranging from 10 months to 92 years old. Almost all cases were used to get high, and only 6 cases were attributed to medical or self-improvement reasons. Psilocybin products may be removed from healing centers and administered off-site by a facilitator, opening up the risk to diversion and accidental ingestion, especially by teens and young children. State regulations allow the manufacturing of commercial psilocybin edibles to include soft confections and chocolate, increasing the attractiveness to these products to children and teens. Research shows that young people living near marijuana dispensaries have more favorable view of marijuana. Elected city and county officials should consider that location could also minimize the perception of harm from psilocybin by youth. Research also demonstrates that the proximity and density of alcohol and tobacco outlets increase the access to youth. Some of the problems that a lot of the citizens have with this legislature is the terminology that they used, like natural. Natural is a word to impressionable teens that may be synonymous with healthy. Medicine implies a doctor is prescribing for good health. Healing center suggests that even though no diagnosis, condition, or doctor is required to participate, the use is safe and healthy. When I was doing research on this, I found only one positive research study that found that psilocybin was good in the patient, and I think it was from Stanford or Johns Hopkins, and that was in an end of life setting, so hospice. These healing centers in this town that they want to put are not hospice. They're not end of life. They're just people coming to try to use this. I'm not against experimental drugs. I just think that experimental drugs need to be used in a correct time and place. I would say hospital. But since Prop 122 was voted in, what we can do as a town is to regulate time, place, and manner. And what was proposed to us last time, I believe, was the absolute minimum, which needs to be tightened up in this town. Some things we can do are restrict location of healing centers and all license to light industrial only. Increase the distance of healing centers from schools and childcare centers from 1,000 feet to 1 mile. Add churches to that list of schools and childcare. Require a license to allow for review of facilities and enable enforcement. Restrict the number of healing centers to limit density. Temporary moratorium to monitor impacts on other communities. Prohibit the distribution and manufacturing of chocolates and soft confections to better protect kids from the risk of accidental ingestion. Prohibit healing centers and facilitators from removing, administrating psilocybin chocolates and soft confections outside of the healing center. And this is just a few of the things we can do. It's open up to anything that we have to imagine. I feel very strongly on this issue, and I hope that some of this research will help us when we have a further meeting on this issue. Thank you.
Okay, anything else? Okay. Before we get to the executive session, I just wanted to report out that we were talking about the North I-25 Coalition moving probably to in person, the Standard Regional Transportation Commission and Dr. Cog meeting. But I wanted to point out on the same day that the CML legislative governing session, or for the day, is going to be at the History Colorado. Dr. Cog now has it's been 9 years that Dr. Cog has put on a really nice, and it's a great conference for small towns and their hot topics such as housing and so on. But if you would like to go to that in lieu of the legislation of the CML legislative government update for that day, Dr. Cog is also hosting small town hot topics too. So it starts at 10, it goes until 2. So it's really good. I've gone every year, but somehow this year is on the same day that we have to be somewhere else. So I wanted to point that out. And it's, if you want the link, you can either ask or Mary or I or whoever, but I just wanted to point that out. So it's on the same day. So, which is unfortunate, but I think both of them are a great way to get more training and help us as small towns. So anyway,
Wait, before we go.
yes, I'm sorry.
Just on Trustee Crane's, the whole psilocybin thing, do we need to direct staff to try to use any of that information to try to limit it further? Or is that understood, or does there have to be a motion on that? I mean,
I'll be good, Marcus.
I don't think there needs to be a motion on it. I mean, I think we heard a lot of those concerns when we brought it originally for public hearing. We're currently, Jason and his department are working with one of the attorneys in my office to make some revisions to bring that back. There's certain, I tend to agree with all of the concerns as stated. There are certain of those items that the town just won't regulate at all, right? It's up to the state to actually regulate the actual ultimate licensees.
Right.
But in terms of the locations, that's something that very clearly we have authority to regulate, and that's something that we're in the process of making revisions, and we'll bring it back. So heard loud and clear, and we're in the process of making those revisions. So
okay, thank you.
Welcome. Okay. I really want to take just a couple minutes for a break before we go into executive session. So I would really like just to have 2 minutes to go to the restroom.
Go.
So could we just convene back at 9:30 and then we will go into number 15, our executive session? Could we possibly do that? Okay. Thank you very much. Mary, could you stop the motion to extend our meeting tonight to a time certain? And I would ask for that motion.
I move to extend our meeting time to 11:59 PM. We don't have to stay that long.
February 10th, 2025, ma'am.
On February 10th, 2025.
Okay, is there a second?
Second.
All right, roll call, please, Mary.
I'm catching up here. Sorry. Trustee Hagan,
Yes.
Trustee Babcock,
Yes.
Mayor Pro Tem Harris,
Yes.
Trustee Schranz,
Yes.
Trustee Adams,
Yes.
Trustee Crane,
Yes.
Mayor Whitlow.
All right, thank you. Motion carries. We will extend the meeting until 11:59, February 10th, 2025. Next on our agenda is our executive session pursuant to CRS 24-6-4024B for conference with town attorney regarding specific legal questions regarding allegations made by public comment at the January 13th, 2025 regular meeting. Is there a motion to go into executive session?
I move to go into the executive session.
There's a second.
Second.
Thank you.
You have to say the whole
I
damn
don't
thing.
have it.
Got it out.
You go for it.
Okay. I move to go into executive session pursuant to CRS 24-6-4024B for a conference with the town attorney regarding specific legal questions regarding allegations made during public comment at the January 13th, 2025 regular meeting.
Now is there a second? Dave, was that you? Was that you?
It was Herman.
Herman, okay. Roll call, please, Mary.
Trustee Babcock,
Yes.
Trustee Schranz,
Yes.
Trustee Hagan,
Yes.
Trustee Crane,
Yes.
Mayor Pro Tem Harris,
Yes.
Trustee Adams,
Yes.
Mayor Whitlow.
Yes. The time now is 9:35 and we will turn off the recording and adjourn into executive session. We will restart the recording for the executive session.
Thank you for anybody who is online. We are going to stop the online portion of this meeting for the executive session.